Camera City Council is now in session. Would the clerk please take the roll?
Councilmember Culver.
Present.
Councilmember Marshall.
Present.
Councilmember Sassen.
Here.
Councilmember Shrubnik.
Here.
Deputy Mayor O'Kane.
Here.
Councilmember Lutsis.
Here.
Mayor Herbig.
Here.
All present.
Next on the agenda is a training and Open Public Meetings Act and Public Records Act training presented by Megan Damerow, Attorney General's Office.
Helps if you turn them on. There we go.
Does help.
I can't tell you how many times I've done that where I start talking and it doesn't work. So thank you for inviting us to come spend some time with you this evening. I'll give you brief introductions. Yes,
Could you move the light just a little closer? Thank you.
better. Okay. I'm Morgan Damerow. I'm an attorney with the AG's office. I wear a couple different hats with the office. One of them is I am the lead attorney for our public records consultation program. And then where we work with local governments on public records issues. And as of about a year ago, Mr. Ferguson appointed me as being the Open Government Ombuds, meaning I do a lot of the same things, but with the OPMA. So that's why I was asked to come spend some time with you this evening. I'll turn it over to my colleague.
Hello, everybody. My name is Melissa Drury. I am also with the Attorney General's office. I am a public records officer there currently. I actually have been with them for a little over a year, and I've been with the local government program about 6 months now. So yeah, thank you for having us this evening.
So where we're going to go this evening, we're going to start off with just a quick dive into some big picture issues in terms of the significance of open government. And then we'll shift into the Public Records Act, walk through that training. Melissa will be working with me on that one. And then I'll switch and we'll talk about the OPMA for the rest of our time. One thing to keep in mind, and I know actually during the pandemic, I did a training with the city via Zoom because that's what we had at the point. But the OPMA and the PRA are one of those laws that change pretty quickly over time. The PRA is one that's pretty heavily litigated, and each time the legislature is in Olympia, they make changes to it. OPMA, not quite so much, but that's why it's nice to come back and do a refresher training for those of you who were on council last time, and for those of you who are new, be able to satisfy your PRA and your OPMA training. One thing I do want to emphasize is goal here tonight is to complete that training so you have a good foundation to both of these laws. Many times the best thing you can do is take advantage of your resources. One is your public records officer. The other one is obviously call your city attorney, Don Raton. It's a great resource to take advantage of them. I like to start with this kind of a principle. It doesn't matter whether we're talking about the OPMA or the PRA. Interestingly enough, the legislature in updating both of these laws has incorporated this language into both the OPMA and the PRA. This idea that in working for public sector, being elected to office, it's not a position where it's absolute power and authority. It is a position where it's delegated authority. And the OPMA and the PRA are the tools that people get to use to understand what's going on. Public Records Act is that ability to look at what we are writing, look at what we're relying on in making decisions. And then the OPMA is then to watch the governing body actually doing its work from start to finish. And we'll talk about some of the changes that came into that over this last year as well. Reasons you should care about these laws, aside from the fact that they're the laws, it's always good to comply with the law. And I'm just going to start off with the upper right-hand corner this evening, talking about some headlines. And these are just headlines I grabbed from various newspapers and articles across the state, talking about agencies that ended up in PRA litigation with these ones. And not so much I want to get into the facts of those cases, but more talk about the impacts that headlines have. And when you start talking about the perceptions that people have on the work that I do in my job or the work that you all do as council members, people form their impressions based upon these headlines. And so the more you can insulate yourself against these kinds of lawsuits, the better off you'll be. Because people in many ways believe that these laws are easy. And I'll admit some of the parts of them are, but other parts are not. And so the more you know, the more you're able to avoid hopefully ending up in a lawsuit. Obviously, we can't stop people from filing the lawsuits, but if it's done properly from the beginning to the end, you can really minimize your chances. Because otherwise, people, they think that these laws are easy to do. And when they start seeing violations of the OPMA and the PRA, they start thinking, oh my goodness, what else are these people doing? They can't get this easy stuff right. There must be, the house must be on fire or something like that. And so it's just a good reminder to, those kinds of perceptions that come. Like I said, you can't stop lawsuits, but hopefully you're positioned well either to be successful in them, but a lot of them can be avoided up front by complying with the laws, obviously. Other reasons you should care about this is because of the legal repercussions. I'm going to stick with the PRA because it has the bigger, oh my goodness factor. There are repercussions for getting these laws wrong. When we start talking about it from the PRA perspective, the biggest judgment we've seen against a jurisdiction in the state of Washington so far is a $2.6 million judgment. Full fairness, that was overturned on appeal. And I know I've seen an email that talks about what the final settlement number was. It was quite a bit less. City of Tacoma unfortunately still has the high watermark. There was a $1.7 million judgment. The reason I want to talk about that is because your insurance companies are not going to cover that. That is coming out of your operating budgets. More typically, when we start talking about PRA implications and violations, it's not uncommon for lawsuits to end up with awards of, when you include both penalties and attorney's fees, of $50,000 or $60,000. And again, in my world, that's real money. That's things that you're going to have to make some hard decisions on. I'd like to be, full fairness. The lowest PRA judgment we've seen so far is a $14 penalty. Yeah, probably admit you can probably absorb that one pretty easily. But more typically, it is in the $30,000, $40,000, $50,000 mark for a PRA case, and they can exceed $100,000 depending upon the nature without too much work. Finally, to finish off, the reason you should care about these laws is, and I really like this quote from Justice Brandeis. Justice Brandeis was a Supreme Court justice back in the early 1900s, and concerned with good decision-making in the public sector. And he was writing about how do we encourage that? How do we make that happen? So if you read a lot of what he was writing, he works in this quote about sunlight being the best disinfectant. That idea that people make good decisions when it happens in this kind of a venue, when ideas of, okay, what's best for the community, what's best for the issue we're trying to address versus, what other factors might be coming into play. Other reason I like this, just from a PRA kind of nerd kind of standpoint, is I like the idea that, he's talking about sunlight being the best disinfectant for good decision-making. In the early 1900s, now knowing what we know about UV light and things like that, I just think it's kind of a nice analogy in terms of how to make good decisions and how to make them clean. But with that, I'm going to jump into the PRA itself. I'm not going to spend a lot of time on history. There is a whole lot more we could talk about, but we have limited time this evening. So I want to come back to this principle when we start talking about the PRA. And if you read any of the decisions that come out of any of the courts, you will see this quote or one very close to it, talking about the purpose of the PRA is to increase transparency. And part of the reason that the courts start here is because of where we got the PRA. It was passed by initiative in 1972. And 1972, I was 4 years old, and I didn't really much care about the Public Records Act. My life was all Legos, that world. But when it passed in 1972, we're talking about something that was hugely popular, passed by over 70%. And so that's the backdrop that the courts are looking at when they're looking at these issues. And that's carried through to the current day. They always talk about this idea of liberally construing the Public Records Act in favor of transparency. And so the reason I want to mention it is to suggest a mind frame, a mindset. Think about the PRA from a customer service point of view. Sometimes when you see public records requests, you get that first moment of like, oh my goodness, this is going to be a lot of work. It is going to be a lot of work for you and for your staff. But it's really a customer service. People get to see what it is that you're all doing, what I do in my job, what Melissa does in her job. And if people can understand that and see what it is that we do, then it takes the idea away from having a conversation about, oh, this is because of this contract went this way, because of this ulterior motive, to let's have a conversation about policy. Let's talk about what should we do. Do we want to be doing this or do we not want to be doing this? And hopefully taking it out of those kinds of unknown questions. Because if people don't know what's going on, a lot of times they will fill in the blanks, and they'll fill in with presuppositions, with ideas they form off headlines, which many times aren't accurate, but that's really what the laws are designed to do is, and specifically with the PRAs, so people can see what's going on, see the memos, see the decision-making process, what you're relying upon.
All right, so under the Public Records Act, agencies, of course, must appoint a public records officer, which I'm sure you have. You are also required to publish procedures which describe your organization, operations, and rules, essentially telling the public how they can make the request, how they can get to you, the hours that they can see records. So that does need to be published. If you are going to charge a fee, you do have to have a fee schedule that has been adopted and published so that requesters can see that. Also, just remember that if a requester does choose to come in to inspect the records, there is no fee for that. And they actually should have up to 30 hours to do so per week if they choose to come in and inspect. So once again, no fee, and they can come in and inspect up to 30 hours a week. Your agency, of course, must maintain a list of laws that you believe exempt or prohibits disclosure. So you do have to have an exemption log to send out to the requester if there are exemptions on the records. Make sure that that does go out so that they are not calling you, asking you, why is there a black box over this? So also continue on, you do need to provide indexes of records, possible. And then again, we're going back to make the non-exempt records available for inspection and copying during customary business hours for that minimum of 30 hours. That is kind of the big one to remember. Again, going back, post customary business hours on the agency's website, that can also be in that policy that was discussed. And then you also do need to keep a public records tracking log. So whenever a request comes in, that information of, who the requester is, if you do have that, they can remain anonymous. What they're requesting, the date they requested, that all does need to be tracked. So make sure that is happening every time a request comes in.
When it comes to the public records, your policy, I really do encourage folks to read it. I'll fully admit it's probably not the most exciting reading, but it really is. It's your playbook. It informs people within your agency how the agency is going to respond to records requests, what the expectations are. Also gives the requester community the opportunity to know what do they need to do, how can they make public records requests. Because the great thing about the Public Records Act and public records requesters is most of them are truly interested in what's going on, and they're trying to find out why decisions are being made. And it gives them, I responded to an email earlier today where somebody was asking, how do I even get records? And I pointed them to the agency and said, here's what it's telling me, here's what you need to do. People will self-help themselves. If you tell them how they can make public records requests, they'll take advantage of that. And it really is that kind of a playbook.
All right, so the main thing that you need to look at when you're finding records for a request is it going to be responsive? How do we determine that? The record goes into a bucket, essentially, as you'll see. So first off, the record has to be a writing. That is very liberal. Please realize that is not just writing on a piece of paper. That is anything. That is video, that is audio, anything. I mean, anything can be considered that writing. So it also has to be relating to the conduct of government or proprietary function. So for example, if you have an email between yourselves just saying, hey, would you like to go get lunch on Tuesday? That's not relating to the conduct of government or proprietary function. It's not going to be responsive. Now, if you do have emails between yourselves saying, hey, we should discuss something at our next meeting, having to do with, a shoreline master plan or something, then yes, that's going to be responsive because it does have to do with the conduct of government or the proprietary function. And then moving on, the record also has to be prepared, owned, used, or retained by the agency. The way you can remember that is the acronym POR. So essentially, every record has to fit into this to be responsive. Is it a writing? Does it relate to the conduct of government or proprietary function? And is it prepared, owned, used, or retained by the agency?
A good example, when I went through those, just kind of differentiate them a little bit. The easy one is prepared. All the emails that are sent, all the memos that are written by you, by your staff, anybody in the city, that's going to be a public record within that definition of prepared. let's say that the city is looking at, I'll stick with the shoreline idea, whether you hire an engineer to come in to do some kind of analysis of the property and whatnot. You get the report back from the consultant, you own that report, it's a public record. Irrespective of the fact that your staff may not have prepared it, it still qualifies for that. Same idea, but let's say that the city's looking at a piece of property, as is the county. And so one of your staff goes down to the county and looks at that report that they purchased from their consultant. That informs their decision-making, and it's get used as part of that decision-making. It's a public record, even though it wasn't something that was commissioned by the city. Where I commonly see this coming up with elected officials such as yourselves is in sessions like this, where you're talking about an issue, talking about something that's informing your decision, and be something like, well, I was on the internet and I saw this study from the University of Washington's economics department, and it was talking about this, and therefore, this is how I feel about this issue. It informs your decision-making. That's going to be a public record. The reason I mention that is because if you get a public records request for any and all records related to that decision, that's got to be on your radar. Oh yeah, I went and I found that doctoral thesis. It was really interesting, and that's got to be pulled inside of the scope of it. And then it's anything that is retained. We'll talk in a second about how long you're supposed to save records from a big picture point of view. But for this point, if you have a record that you could have gotten rid of and you didn't, and it exists as of the moment you get that public records request, the public records request basically freezes everything at that point and says, you've got it. If it's responsive, you must produce it, or you must find an exemption for why you're not going to produce it. So it's got to meet one of those things. Where we've seen the most kind of development recently in this is this idea of, well, what if the records aren't here? What if the records are in personal devices? Personal devices can hold public records if they're created within the scope of employment.
So piggybacking off of that, with personal devices, if you are using your personal cell phone, email address, social media account, et cetera, you may actually have records requested off of that. They are not going to just grab your device and start looking through it, but it will be up to you to attest that you did search your device, and it is required if they are asking for the personal items that would be responsive. But in order to determine if it's going to be responsive, and remember, go back to that, the writing, and then of course, was it prepared on user retain, et cetera. So right now, we need to kind of discuss when your personal items would be responsive. So if the job does require it, it's going to be responsive. If your employer directs it, it's responsive. Or if it furthers the employer's interests, also responsive. So for example, if there's an emergency going on and somebody asks, an employee, hey, can you start reaching out to other employees, let them know, the office is closed, that would be more of a job requires it, employer directs it. So it may be responsive. If you have just text messages between coworkers, again, going back to that, hey, you want to go out Tuesday after work? No, it's not going to be responsive. It doesn't really further anybody's interest, and nobody directed that text message. So again, if your personal items are requested, then you do have to pull those items out, segregate them, and then produce those as public records. Some information may be able to be redacted depending on what is discussed, but some of it may just go out, even if it is somewhat personal.
My best advice when we start talking about this issue is just don't do it. Use your city accounts, resist the temptation to send that personal email from your personal account, work within the city systems, because that way all the records are home. Otherwise, it's kind of like glitter, and they start ending up everywhere if you've ever worked on a glitter project. And that's the equivalent when it comes to public records. Yes.
Just for clarity, so you're speaking specifically to personal accounts. What if someone is sending emails from their personal phone, but it is the city email?
Let me see if I understand. They're being sent from a personal to your city account?
No, so say, how iPhone you might be able to have like 6 or 7 email accounts. And maybe someone added their Office 365 account to their personal phone. If it's it's being sent through, through the cloud or whatever, through that, would that be counted as, I would consider it to be on the city phone. You know, it's on a city device and it's all tracked through city systems. I'm just wondering if I understand that correctly.
And so if it's your email for work and you're logging in on your phone, I believe that is going to be tracked by your email system. But if you're using, say, your Gmail to send out information like to, constituents, hey, here's information, then that's going to be.
Okay, I'm glad, it sounds like I understood it correctly.
Yeah, and
Thank you.
it's not a perfect science as well, because I have three different email accounts, personal, by the way, all personal, on my iPhone. And sometimes I think I'm sending an email out through one account and it goes out through the wrong account. And then I have a sent mail in the wrong place. And so it is possible that, much like glitter, it could end up in the wrong place and then you have something on your personal phone. So it's not, that's why I say it's not a perfect science. Because bottom line, and the reason why it matters is because when we start talking about these records, they're still not my records, they're not your records, they're city records. And there actually is a statute that says, whenever you decide to leave office, those are supposed to be transferred to your successor. And part of the way to ensure that happens is just don't take them home with you. And one thing I caution people is it's kind of a two-part analysis. One is, I mentioned don't use your personal devices, don't use your personal Twitter account or whatever it is that whatever you're thinking about using. Same way as the flip side, don't put your personal life into public records. Try your best to firewall the two, because there's times where, if there is personal information in a public record, there's no exemption for this part of the record isn't responsive. That was tried by an agency and it didn't go well. So I know sometimes it's a little bit sterile, but really try to respect the lanes of travel and do everything you like to do outside of serving in your role on your personal devices, and push everything you can into your personal devices, into your work devices when he's talking about council business. And then you always get the issue, well, people know me, they know I'm on city council, and so they sent me an email to my personal device. What do I do? Best advice is forward it to the city system the second you see it, get it back to where it belongs.
Okay, so records retention, this is going back to that used, owned, retained that we discussed in the buckets. So with retention, every document has some sort of minimum retention. It may be 2 years, maybe 6 years, it all depends. The information for retention on records can be found on the Secretary of State's website. They do have the retention schedules on there, and they do vary. So there is one for actually city, and then there's also just a general one for government records that tell you whether you should be sending the items to SOS for retention, or to archives for retention, or if you can destroy the records. Again, when you can get rid of the records, it is best to do so. If you hold on to them, you do have to produce them, and that can happen. So it is always good to kind of go through once a year and walk and see if there's things that you can either ship over to archives, because once you do ship it to archives, a request can come in and then you get to say, it's with state archives, go ask them, and you are done. You close it out, you are done. Whereas if you have the records, you now have to go find the boxes, have to dig for those old records, and it becomes your issue. I know, because I was handed records from 1983 when I was at Mason County and had to deal with all that. So they will haunt you for a long time. So as soon as you can, try and walk through and either destroy and or transfer those records. Makes life a lot easier.
I want to drill down a little bit deeper into the specifics of how do you process public records? And this isn't work that's all going to come your way. The thing is, you have a public records officer, they'll take care of these things. But I think it is important to know kind of what happens. Other times we talk with folks, I talk about, the leadership of the agency really sets the tone for what happens. And we've seen some cases in other parts of the state where people have been subject to recall, and part of the basis for the recall has been not complying with these laws. And so to give you a sense of kind of what happens, so that it also helps just so you know when your public records officer is asking you about something, kind of say, oh, this is why they're asking me, because they're trying to work through this piece of it. It all starts with a request, and that's, and up into this, we're doing everything else that you need to do as elected to council. Your staff is doing everything else that they do. And then all of a sudden, a public records request comes in, and it's one more thing that has to be accomplished. It is one of the essential functions of an agency, is this transparency. And it's triggered by that moment. And we'll talk about specifics about what requests look like in just a second. That triggers what's called a 5-day letter. Within 5 business days, your agency has to respond, which is why you may get an email from your public records officer saying, I'd like to know if you have any responsive records to this. It's not necessarily that they're trying to micromanage you. They're trying to figure out how big is the bucket of records that they need to produce, because there's things they're trying to estimate, like what's the reasonable estimate of time for producing them. And then part and parcel of that is searching for records. And we'll talk a little bit about what that looks like in the obligation, but that's something that falls on everybody has a hand in searching for records. It's not just 1 or 2 people. Each of us is responsible for our own records in many ways. Somebody then gets to review and redact everything. There's not necessarily going to be redactions on all the records, but somebody's going to spend quality time going document by document by document, doing the best that they can to make sure that protected information is not turned over. Things like Social Security numbers. Employees have this wonderful habit of putting Social Security numbers in the weirdest places. And I don't know why, but they do this. And so this is why all the records have to be looked through, looking for that kind of protected information. Next step is production, actually a relatively easy step. It's basically your requester, here's either the records you requested, or you may get into what you see on the screen with an installment. More and more requests are any and all records related to, versus if you went back 15, 20 years, more people are asking for, I want that record or that document. So we've seen this proliferation in the size of requests. So more and more requests are being handled through this installment, where reasonable installments are being given out over a period of time. And then the request is closed. Every request for records follows this basic model. Bits and pieces change depending on the nature of the request, the scope of the request. Sometimes searching for records is more challenging than others. Other times reviewing records is very challenging. So some of the dynamics change, but it's the same basic process all the way along. So getting to that starting point, when we start talking about a request for records, there is no required format for public records requests. Years ago in the PRA, there was some language to that effect. That's been removed by the legislature. Requests can come in now if you have a form, and I encourage agencies to develop a form. I encourage agencies to take advantage of the online portals or a home-built portal on their website. Because the thing about it is most requesters are just trying to get records, and so they'll take advantage of that. Where we've seen the development in this recently, though, is they're not just requests that necessarily come to the public records officer. They can come throughout the agency. The city of Tacoma had a case a little while ago, now 2 years ago, where the request actually went to 2 of the attorneys. And so what the Court of Appeals looked at was the nature of the way in which the request was submitted and the nature of the records sought as to whether this was a valid public records request, because what they're trying to ascertain is, did it put the agency on fair notice that somebody was asking for records? What we see is a lot of people will not cite the Public Records Act 4256 or say PRA. What they commonly cite is FOIA, because that's kind of what we know just in front of our brains kind of thinking about it. They don't even have to do that. It just has to be apparent on its face that they're looking for public records. What that means is, as council members and as mayors, that you could very well see these in your email. And so my advice to you is basically a hot potato theory. Get it to your public records officers the second you see it, because the clock is ticking. 5 business days starts to run the day the agency received it. So if it's a Tuesday and you haven't checked your email since last Friday, you may have lost 2 days already. So this is a tight timeline for that initial response. And you might think this is the only one official timeline in the PRA. And you might think, oh, well, it's not that big a deal. This is something the courts take notice of. There was a case in Eastern Washington that didn't go well for jurisdiction. And the court's analysis of the case started with, they started making mistakes in the PRA on day 6 when they didn't get this done. And then it went south from there. And so that's my best advice, is if you see one of these in an email, forward it on. If somebody were to approach you and say, hey, I'd like to make a public records request, first response, I do this with people that talk with me, and they call my phone number. I say, Great. How about this? We have a public records officer. She's our agency expert. She can make sure this happens right. Let me transfer you to you. Is that okay? Most of the people say yes. I've had a couple of people say no for various reasons, and then the next response is, okay, great. Then make sure, get your pen out, start taking notes. Who are you speaking with? They don't have to give you their name. Most people will. Make sure you get some way to contact them, whether it's an email or an address, a telephone number, something. And your best description of what they're asking for, and write it down and mirror it back to them. So let me see if I understand. You're looking for this, yes. The second you're done with that conversation, forward it on some way to your public records officers so they can follow up to make sure there's no outlying issues. The one thing that requesters have to do in this realm is they have to ask for identifiable records. We have to be able to understand what they're asking for, which is where that dialogue really comes into that play. That's where that customer service comes into play, helping them articulate what it is that they're looking for, maybe what it is that you have. Some people don't know exactly what records we have. But this is also to differentiate between, this is a request for records. People get to see the piece of paper. A lot of times I see what people think are public records requests, and it starts off with, why did council make this decision? That's very likely not a valid public records request. Commonly what I've seen agencies do in those circumstances is in their 5-day letter say, this is not a valid public records request because you're asking for information. However, we do have this report that might be useful to you. Here you go. It depends on the situation. You have to work it through case by case. Some common issues that come up when I start talking with folks is, why do they want the records? And the correct answer to that is, I don't care. What people are going to do with records is whatever they want to do with records. The media asks for records all the time because they're working on stories. People interested in what's going on in the community want to know what's underlying the decisions, what's going on. That may be why they want records. There's been some cases recently looking at asking that specific question of an individual, and the courts have repeatedly said now it doesn't matter. What matters in the public records realm is, what did your agency do in responding to public records requests? Did you take this seriously? Did you meet your obligations? What the requester's motives are in making these requests, by and large, doesn't matter. There are a couple of exceptions with things like commercial purpose for a list of individuals, and there's another exemption when we start talking about a few things with media requests. But by and large, it doesn't matter, and all requesters are entitled to the same treatment. Doesn't mean they're going to get the same records necessarily, because the identity of a requester, if you know who it is, may impact whether an exemption applies. Example that, privacy wouldn't attach if the record was about me, but it may attach if Melissa was asking for the same record about me. So sometimes the identity of the requester will matter if you know. But by and large, that's not the question. The question is, what do you want? What's our process? Here you go. It's that kind of analysis.
Okay, so when the public records officer is responding to the requester with that 5-day letter, there are a couple of options for them. The first is they can provide the record. They have it, close it out, done, good to go. Second, they can provide an internet address and link on the website. Now, it does have to be to your city's website. They can't just send a link. Like if they were looking up something on the Attorney General's site, they found they could not send the link as fulfilling the records request to the Attorney General's site. You can direct people there and say, for more information, you can go here, but that cannot be the final, go here, we're done. The records officer can acknowledge receipt and request clarification. So if that records request is not entirely clear, they can go back to the requester and ask for clarity on that. If there are portions of the request they understand, they should start working on those, because the requester may not respond to that clarification, but at least they can close out the rest of it. They can deny the public records request if for some reason it is for say another agency, if the records aren't held here, or if they've been sent over to archives, for example. They can also acknowledge receipt of the request and provide a reasonable estimate of time to respond to the request. So this is going back to when the records officer comes to you and says, hey, do you have records, and can you let me know how much you actually have responsive to this request? If they need to send out an estimate of time, this helps them do so, because they know how long it's going to take you to get into your records, to produce them for the other divisions, et cetera. So it does help if you can get them at even just an estimate ballpark on a number of documents or when you can provide those by. But those are the options that the records officer has to respond within the first 5 days to the requester.
Something to keep in mind when you start talking about requests for clarification is there's commonly, some requests are very large and they're just a very big box of records somebody wants. Asking, you can always engage with requesters, talk with requesters and say, you know, maybe you tell me a little bit more. They don't have to tell you why they want the records, but maybe give you some idea, we can focus this request, get you what you want more quickly. That's far different from asking for clarification. Clarification is really, we don't understand what you're asking for, whether it's you can't read the handwriting or it looks like it's been run through Google Translate to 5 or 6 different languages, that kind of a thing. And so sometimes those get confused. So we are talking with a fair number of folks about that issue. Wanted to mention one thing about the website. It has to be your website, but this is where being proactive can be really effective. You know, I grew up here in Kenmore, and I know Lake Point's been talked about being developed for decades, and someday it will happen. I have faith in that. And I guarantee every time it's come up, people take interest. I can give you a good example of where a different agency had the similar idea. Clearland was looking at a redevelopment on the edge of town, and some members of the community were very much in favor of it, others not. They were getting buried by public records requests. They proactively built part of their webpage to being, here's everything we know about this this redevelopment area. And by proactively pushing out information, it's tough to do it with everything. I fully acknowledge that. But when you get those high public interest issues, you can get ahead of the curve. And that's, you know, it really does help take the burden away on the other side of things. Otherwise, people will ask for this stuff. Then they can get it. But if you make it so they can self-help, great, you're being even more transparent.
Right, so everybody does have the responsibility to search for their own records when the request comes in. This quote is really a good one to remember. The adequacy of a search is judged by a standard of reasonableness. That is, the search must be reasonably calculated to uncover all relevant documents. The reason I like to point that out is because no search is going to be 100% perfect, and you are not required to go into every single filing cabinet and look for a piece of paper, You know, you're not on a search for treasure. You need to understand, though, where records are held within your agency and who holds those records so that you can talk with them and figure out how to get said records. Again, you don't have to go back to every single drawer, but you should know, you know, I know who in Public Works has these records, who in Building and Planning, who do I contact? You also need to know the difference between easy versus complex searches. Sometimes you can just go into Outlook and boom, there it is. Other times though, you are gonna have to dig a little bit and things are gonna lead you on different trails when you start talking to people who remember, oh, we also did this, we also did that. It's gonna take you down. You need to, of course, have assigned responsibility. There is going to be the central/division representatives and individual employees. So central is going to be your records officer who's, you know, setting up everything, having the main points of contact. You've got division representatives, again, who has the records at, you know, Public Works, Building, Planning, et cetera. And then the individual employees. So if they have a request come in, you know, for Deborah, I apologize, I'm going to pick on you for a moment. Then it's up to you to search your records for what they're asking. So it is up to each individual employee. It is also good to speak with staff about potential search terms. So if you searched for, you know, 2 or 3 words, but you're kind of like, I don't know if I should go any deeper, please talk with staff because again, sometimes people remember things that happen. They remember events, they remember people's names that were involved with the situation. So it is also good to discuss with other employees as well. Beware of acronyms, misspellings, or alternative spellings. Even if the requester writes in a name and you know that it's spelled wrong, going back to Deborah here. So if they added an H at the end, but you know that there is no H, it's up to you to do the search correctly. You know, you can't go back to them and be like, well, you put an H at the end of it, so we don't have anybody with the name Deborah with an H. So you do have to kind of have that customer service again and do a search there.
Don't have to be mind readers. I tell
No.
people all the time, you know, give people what they ask for, no more, no less. But this commonly comes up with hot topic issues where people spell, like, I'll stick with Lake Point. They spell point wrong. And you're like, okay, you're not gonna, they didn't have the E on it. And we put the E on it this time, therefore it's not gonna go well for you.
Yeah.
Those kinds of things.
And then also, like I was just saying, follow the breadcrumbs. You're gonna see things when you start reading emails and go, whoa, this is responsive. I didn't know that. And then it's going to take you off on a whole other path, but you will find other records that you didn't realize existed. That's kind of the fun of doing public records sometimes. You do want to cast a wide net and document all of your search efforts. The documentation is important. You do want to put down any search terms that were used, locations that you did search, and a description of the records, how they were produced and when. So if you send out an installment via email, make sure to note that. That way, if the requester comes back and says, I never got an email, and you can be like, yeah, we sent it out June 3rd. And then you also want to have that description of records not produced. And again, that goes back to that exemption log. You need to have that on record. And the documentation is important because if for some reason a requester comes back a year later and says, hey, I want to go forward, with a lawsuit on this PRA, you're not going to remember what you searched, when you searched, or how you actually gave the records to the requester from a year ago. I mean, you've done 1,000 other things since then. So make sure that you are documenting as much as possible when you're searching.
Yeah, that's the one place where I'm always cautious about making records. This is the one place I always tell people, you cannot over document when it comes to this issue, because this is a common challenge when it comes to public records. Is I was denied access to records. The agency didn't do a proper search, and the requester provides a little bit of information to the judge in support of that, and then the judge will look to the agency and say, okay, agency, prove to me you did it right. And if you can't back it up with what was specifically done, Tacoma, I'm not trying to pick on Tacoma tonight. They've just given us lots of good learning points. Their public records officer did a really good declaration in a case talking about what he did for this request. It was a really common request. This is what I've done in all of these requests. So the judge said, great foundation. You didn't give me enough information. You didn't tell me what you did this time. So when you find, when you're helping by searching for records that you're responsible for, and I don't know exactly how you're documenting, whether it's you're sending an email to your public records officer or whether you're using a portal, document that so that you're a year later and 1,000 other things, you've got something, oh yeah, that's what I did, versus, yeah, I got nothing. Because it's going to be on you all as a city to prove that it was done properly. I want to shift gears for a second. We've found the records, and now somebody is looking over the records, and I'm going to not assign that task to you, I think. But I want to give you a sense of what we're talking about when we're talking about exemptions, rather. When we start talking about all these records, it's really a series of yes/no questions. It's a question of, do we have responsive records? Yes or no. If the answer is yes, then the next question is there an exemption to these records? Yes or no. Because if there are responsive records, the presumption is that people get to see them, at minimum know that they exist. And what allows us to not produce records are these things called exemptions. Those exemptions are narrowly construed. And just to give you a sense of how many we're talking about, there are currently over 600 exemptions in state law. And that's not counting the exemptions we rely on in federal law. I've known of a couple of times when treaties have been relied upon for exemptions. What we're looking for is either something that specifically says this is exempt for 4256. A lot of times the legislature is writing that into the bills now. I was reading bills this morning and saw that repeatedly. Other times what the court's looking for is there something that indicates that this record is supposed to be exempt? It's supposed to be confidential. People aren't supposed to see it. Common ones we talk about are things like HIPAA or the Americans with Disability Act. They don't talk about the Public Records Act at all, but obviously that is why we protect a lot of very sensitive information. If the agency is the one asserting that exemption, the burden of proof is on the agency. It's the same idea as what I was talking about with searching for records, is the agency has to say, this is exempt for this reason, and in producing that record with the exemption, has to produce what's called an exemption log, where we cite what the law is and how it applies to that record so the requester can understand what it is that they're not seeing. There is this idea, this concept of silent withholding, and it can occur one of two ways. One is because there is a record that we didn't find, we didn't do a proper search, or there's a record that we didn't disclose its existence, going back to those yes/no questions. Whichever way, I hope you never find yourself in that situation where you find you've silently withheld a record. That's something that the courts do not look favorably upon. Keep in mind that, going back to what Melissa was talking about with, the search doesn't have to find every record. It has to look everywhere it's reasonably anticipated that record is going to be found. So when a record does go wandering and somebody files it in the wrong place, or the click drag puts it someplace weird and electronic search doesn't find it because it's a graphic file, Those things happen, and the courts recognize that, which is where this idea came from. It's a good example, though, of kind of where where we get what we do with the PRA. Most of it is in the Public Records Act, but a lot of it is influenced by court decisions. And this idea of having to search everywhere it's reasonably anticipated comes from a court decision when the court was trying to ascertain whether an agency had fulfilled its obligations. Thing to keep in mind, once we have those records, we're applying exemptions. The majority of them are discretionary, meaning your agency can choose not to apply them. Agencies do their best, but what that means is that sometimes the requesters will come back to you and say, did you really mean to apply that exemption? I don't think it applies. And you can take a look at it and go, we still think it applies, but based on these facts, these circumstances, we're going to waive that. We're not going to apply to this particular records release. It doesn't mean that exemption is waived forever and ever. It means for this particular request, we're choosing not to apply it. I want to talk about one specific idea within the Public Records Act, because this is one that I get a lot of phone calls about, and this is idea of privacy. Privacy is defined by the Public Records Act. It pulls this definition comes out of years and years of case law. But basically, for the Public Records Act, things are private if they are highly offensive to a reasonable person and not of legitimate public concern. This is a very high standard, just to use the same word from the top line there. And the courts have talked about this in terms of being accused of criminal misconduct is offensive, but it's not highly offensive. The kind of stuff that we're talking about with this definition are the things that you only talk about at home. You talk about with your partner, you talk about with your counselor, with your attorney, your doctor. It's that core bit of you that doesn't go on social media. It doesn't you don't talk with Wilson over the back fence about. It is a very high standard when we start talking about this. It's also not a standalone exemption. It has to be incorporated into some other exemption within the PRA. This is but a definition. An example I put up on the screen was, information in employees' personnel files is exempt to the extent it would violate their right to privacy. This is what allows agencies to withhold things like annual evaluations. The courts have determined that's not of legitimate public concern. But it's a record by record kind of analysis. I'm not going to try to go through all 600 exemptions because I cannot keep them all in my head. There's way too many of them. I have resources that I rely upon, but just give you a sense of what's out there. There is now an exemption for employee dates of birth. This is one of those places where there's a difference between requesters. If it is the traditional media making that request, they're entitled to the full date of birth, month, year, everything. If it's anybody else, they get the day of birth. The month and the year are exempt. Why that is the legislature decided. Sometimes we get these exemptions and we read them and go, okay, that's the exemption that we have. And the courts look at it that exact way. This is a relatively new exemption. This came in 2019 at the end of a series of litigation where our Supreme Court, to give you an example of how tightly they construe these exemptions, there was an exemption for law enforcement that matches what's currently out there. There was an exemption for dependent state of birth. And they said there is no exemption for public employees at that time. Now there is, because the legislature had specifically spoken to it in these other places, didn't identify employees like me at that time. The court recognized that bad things could happen if this was released, identity theft. And the court said, we're sorry, but this is something that the legislature needs to address. It's not what the courts will come in and create an exemption, is why I'm mentioning this. It comes back to specifically what is written. There's exemptions for applications for employment. Things like you would expect. There's driver's license number, bank accounts, information in personnel files, as I've mentioned. There are, like I said, over 600 exemptions out there.
Okay, so for records production, again, going back to the inspection portion, if a requester asks to inspect records, you do need to notify the requester that they do have records available, and you want to let them know how long they will be available. So this kind of mirrors also when you let a requester know if you're going to charge them, then they have a specific set of days per your policy. It's probably 15 to 30 days. So this kind of falls under that as well. But this one, you let them know how long the records will be available. And then they can set up a time to come in and view said records for inspection. If they are going to be produced, you want to let them know if there's going to be any fee, and of course, provide that timeline for them to pay. If they do not pay within that particular timeline, you do have the right to close out the request. If they do pay, of course, provide the records to the requester. And if you do need to, because it's a large records request, you can do multiple installments. That is perfectly fine. You do just have to give a reasonable time estimate when you are telling them about their next installment coming up. And once again, you can provide an installment by providing links to records on your own website.
This is where the public records has some default fees, and it's really designed for recouping the final moment when you are, and to give you a sense of what they are, I believe you've adopted them, if I remember correctly. It's 5 cents for every 4 attachments to an email or you put out into a cloud-based system. 10 cents per gigabyte, 15 cents for photocopying something, or 10 cents for scanning something to produce it to the requester. This is not going to at all come close to the cost of doing business when it comes to transparency, but it is one of the few places in the PRA where where requesters basically have a little bit of investment, and they have to show that they're serious for it. Final piece is, when it comes to closing the request, and this again is going to be done by your public records officer. The key takeaways is that so far the courts have been very consistent in saying there's a 1-year statute of limitations, and so you'll see this if you happen to look at those closure letters that say, "Dear requester, this is our final installment. We believe we have satisfied our obligation, and we'll be producing no further records to you." It's a nice line in the sand that says, "We think we're done." They can always talk with you. "I think I didn't get something," but it's a nice, clear kind of demarcation that we believe we are done. And then your public records officer is going to arrange that file for basically for storage. There's a 2-year retention for public records requests, and so 2 years after the request is closed, then they can be properly disposed of. And there is a sense out there, that agencies are generally following this. They're in the height of the pandemic, agencies got behind. 34 school districts in the state got a request from a individual who identified themselves as PRA auditor, who wanted 11 years worth of records requests in the production. And so basically for a few districts, they end up cloning 11 years worth of PRA. It's that idea of manage records, get rid of records when you can. Don't delete records early, please, because that causes all kinds of problems. And then people call me and want to know what they can do about it. Manage records the way they're supposed to. Going back to that lower right-hand corner and kind of finishing off our conversation about the PRA. So who gets to make the determination as to whether the agency has fulfilled its obligation? It's the courts. Superior Court judge, in this case, it would be the King County Superior Court judge, is presented. It's a PRA civil lawsuit, and if the requesters can challenge one of 2 things: either that they were denied access to records, you took too long, records weren't produced, something like that, or that the estimate of time wasn't reasonable. And if the agency is found to have denied access to records, then it's at the discretion of the trial court judge as to what the penalties are going to be. And the range is anywhere between $0 to $100 per day per record. There are some requesters who then will sit on a public records request case for a good chunk of the year, because every time the worth spins around, that's a cha-ching kind of moment. It's in the discretion of the court as to how they take all that into account. But that's the repercussions. This multiplier could go on to the year. Most requesters are not that way. Most requesters are truly interested in records, trying to figure out what's going on. If they think they've been denied access to records, they will come back and hopefully talk to you, hopefully talk with your public records officer. That's where that customer service comes into play. I know of, pardon me, some public records officers that by appearance are rather, gruff, but get lots of thank you letters from requesters because they go a step further. They're willing to share information about what's going on. The other piece that comes into play with this is attorney's fees. Pardon me. If you're found to have denied access to records, the court will select someplace in there as to what the penalty is going to be. And then it's presumptive that you're paying their attorney's fees as well. To give you an example of that, there's a county in Washington that went into court on day one and said there was a mistake. We made a mistake with this request. The case ended up being resolved ultimately by a judge for $15,000 in penalties and $45,000 in attorney's fees. And this was something that happened, and they acknowledged that they could show the agency as a whole took it properly. This was because of one person didn't do it properly. And when I see those kinds of penalties, yeah, they hurt, but those aren't outlandish, and especially when we start talking about attorney's fees nowadays. And again, the requester's motives are irrelevant. There are some unique provisions when it comes to folks that are in custody, Department of Corrections. That was addressing an issue back in the early 2000s where there was basically an industry in corrections where inmate requesters were requesting records all over the state, knowing about the penalty provisions. And at that point, the penalty minimum was $5 per day. And so it was an issue that the court addressed. Excuse me, that the legislature addressed. So to wrap up our discussion about the Public Records Act, key takeaways. All the records are presumed open. If it fits in all three of those buckets, if it's a writing, if it's some way we can record some kind of communication, if it's related to the conduct of government, if it is prepared, owned, used, or retained, if it's responsive to the request, it's presumed open. People have the right to see it, right to know it exists at least. You can only withhold the records or information in those records if there's a specific exemption. And that's an expectation of the PRA in general. If there is one small piece of exempt information on a record, the expectation is that we will use Adobe or some other tool, or it could be a Sharpie, to redact just that piece of information and produce the rest. And that's determined based upon the record itself. You hold that record up in front of you, you say, what can I determine from this record? That's how it's determined. And if it's not exempt, it has to be disclosed. Location doesn't matter. It's all about the content of these records. It's all about what they address within them. And then I go back to public retention because records retention, because there is a correlation between the two of these. Obviously, the more you have, the more you have to produce. Not telling you to get rid of things that you're supposed to save, but I've talked to many folks that have like 25 years of records, which is generally about 18 years past retention for almost everything. But that, I might need this someday. If you truly need it someday, if it's that special a document, I'm okay with that, but you're not going to need everything someday. Be selective in how you approach that. Can we answer any questions on the PRA?
Questions on the Public Records Act? Councilmember Culver.
This is a nerdy one. I'm just curious. You mentioned agencies needing to index records. What does that typically look like? Is that by year or category or any recommendations there?
I'm going to give you the favorite attorney answer. It depends. It depends on the record. It depends upon how it makes sense to index records. It also goes back to 1972 when the PRA was passed by initiative, when there were records clerks and we didn't have the benefit of electronic systems. The PRA does allow agencies to decide not to index many records nowadays. It would be too burdensome, but it kind of depends on what it makes sense and how, the idea is how can you facilitate finding them? Maybe by topic and maybe by year, something like that.
Oh, appreciate it. Thank you.
Happy to.
Councilmember Shrepnick.
Yeah, and maybe this is part of your next presentation, I'm not sure, but can you speak a little bit to social media records?
Yeah, happy to. It comes back to content, and this is actually been something that's been litigated a number of times. There was a case out of Tacoma involving the former elected prosecutor, and that led to a gentleman named Arthur West challenging the city of Puyallup and I believe it's Clark County. And most of that was about social media. And the court went back to that scope of employment test and said, okay, is this record that's been, in those cases, they were all council members of various jurisdictions, and said, is this record created within the scope of the employment, part of what the county, the city, whichever the case may be, was trying to accomplish, part of your authority? As an example of that, one of the cases out of Puyallup, one of the council members was talking about things that the county was doing, things that were going on in the community, but not stuff that they were directly responsible for. And so the court said in that case, on those facts, the records that were issued weren't a public record because it wasn't something that the city council at that point was dealing with. It was things that were just kind of going on in the community.
I'll maybe ask a little more pointed
Yeah.
question, sorry.
No.
We've kind of informally, talked about this as, we're allowed to put out a unidirectional piece of information, but not to dialogue. Is that still appropriate advice, or? I mean, I guess I don't want, I can't ask you
No.
for advice, legal advice, but I mean, is that generally an appropriate policy?
And I'll give you my experience working with some of my boards and commissions. I encourage them not to engage in social media, especially, and we will get into this in the next part, because if you're putting this information, these dialogues out in social media, and let's say that 4 of you are friends in that social media and start engaging back and forth, one is you have a meeting. Potentially in that situation. The second is, if it's within the scope of your appointment, you are putting records out there and you're responsible for them. And
Even unidirectional then?
yeah, even if it's you just pushing them out there, they're still, if you're sitting in your job as, City of Kenmore council member, and I'm gonna go back to Lake Point because I like that theory, that theme tonight. Here's what we're doing for Lake Point and here's what you need to know. That's gonna be something that's within the scope of your appointment, very likely. Because that's something that's concerning the city and whatnot. I have no idea where Lake Point stands at this point, but it's something I've been aware of for years.
Any other questions on the Public Records Act? All right.
Great. So let me switch gears, and now we'll put all the records aside, all the paper, and we'll switch gears into talking about this scenario, talking about you all sitting at the dais and talking, doing work, and what does that look like, and what are the expectations? Going back to that idea, that the baseline principles when we start talking about public records, when we start talking about the Open Public Meetings Act, is the purpose behind it is that all the discussions happen in this kind of a setting, that people get to come in, as happens this evening, and see the discussion, watch what happens. If we went back to the late 60s, what we saw in the Public Records Act, I'm stuck in the Public Records Act, in the Open Public Meetings Act, was that the right under the act at that point was to see the final decisions. That was expanded in 1971 to now people get to watch it from start to finish, because really that's where people become informed as to why decisions are made. Where we've seen a step forward, which is kind of a change but not a real big difference, is in historically it's been like this scenario where people get to be present, watch the discussions going on. There's now a specific expectation and a requirement that at any regular meeting in which final action is taken, that there is an opportunity for the public to share their thoughts and to provide public comment. The reason I say that's really a change without a lot of distinction. Most jurisdictions have been doing it for a very long time anyways. The legislature just put some structure behind it, basically. But like I said, the courts will always come back to this idea of being done openly, transparency. They will liberally construe this act the same way they look at the Public Records Act, in terms of what is the more transparent thing? What can we do to make this transparent? And I encourage folks to think about it that way when you're facing one of those tough decisions where it's like, okay, which way do I go with here? Which is the decision that bends more towards transparency? That's kind of the frame of reference you should have. The basic requirements when we start talking about the Open Public Meetings Act is that all the meetings of a governing body of a public agency have to be open. People have to be given the opportunity to attend. You can't put restrictions in place. Basically, open door that happened this evening. People get to walk in with they don't have to sign up they don't have to buy tickets, anything like that. That's really the bedrock when it comes down to the OPMA. We're gonna break this down a little bit, and we start talking about the components of it in the next few slides. Where we've also seen a kind of a growth and development is what we all lived through. When you think about the pandemic, and when I first was talking with council, it was the Brady Bunch view, and I was down in Olympia, and I think we were so glad to have that behind us. But there was a recognition that public participation in meetings went way up, and that was either because people were really interested as to what was going on, or we were so desperate for content we'd watch anything. But it was true. I mean, I did this. I was watching school board meetings having to do with my school district because I was interested in what was going on. And so the legislature has built something, has built that in as well. There's an encouragement that agencies continue to use those tools, continue to use the remote tools so people can participate wherever they happen to be and not have to carve part of their day out to come down to council chambers. It's not a requirement yet. We've seen one inroad into that with school districts. I'll mention that just briefly. I think we'll see more of that in the future. But those are the basic requirements and encouragements as it stands right now. So when we start talking about what is a governing body, it is a multi-member body. It is the Kenmore City Council. I don't think that's a surprise to anybody, but it can go deeper than that. That's why I want to spend a second here talking. It can go if you create a subcommittee that has delegated authority, acts on your behalf, takes public testimony, conducts a hearing on your behalf, something like that. The Open Public Meetings Act, the requirements flow to that group as well. Someplace you have to watch out for with this is if a group has de facto decision-making. The hypothetical might be, let's say that you create a subcommittee to look at grant applications and bring you back the top 3 grant applications. They don't get past that body, that screening, then they don't get to you in terms of the decision-making. That's de facto decision-making. That group would also be subject to the OPMA. Purely advisory bodies, let's say that I'm going to come back to Lake Point again. You were looking at other ideas, and so you create a subcommittee to go out and find, 5 other, whatever they can in terms of communities that have faced similar issues. Bring us back a report what they did, just purely informational, not binding the agent, not binding your decision making, not in any way. Those group wouldn't be subject. That's purely advisory, not subject to the OPMA. I wanted to mention it just because many people think about it from a leadership point of view and not from something if they have delegated authority or something like that. So it can go deeper. My advice in all the situations, it's a great time to talk with your attorney about what it is you're setting up. Are they subject? Because it's very fact specific as to whether it's there are going to be or not. I'm giving you the kind of the guidepost for it. Next piece is it has to be a meeting. One of the nice things we know about the Open Public Meetings Act when it comes to meetings is that first off, there has to be action. I'm going to table that for a second. That's going to be literally the 2 slides from now. But it has to be a quorum of the governing body present. So if there are 7 council members, then 4 is the magic number, so to speak. If there are 4 council members discussing agency business in any context, it can be down at the hangar. It could be, you happen to run into each other at Safeway, anything like that. Then if you're taking action, discussing agency business, you've got an issue in terms of your OPMA compliance. It doesn't matter what you call it. The OPMA, much like the PRA, looks at the content. It looks at what is going on here. You can call it a workshop, you can call it a retreat, you can call it a regular meeting. It doesn't really matter what the title is. It's all about the function. There is a bright line in here. Simply receiving information is not a meeting. So if you were to just get an email saying, here's something to consider, or here's some information for our next board meeting, our city council meeting, passively receiving information, it's okay. That is also what allows you to go to, say, AWC puts on a workshop. Then you could go to one of their workshops or their new council member trainings, because you're passively receiving information. You're attending training to do your job properly, not hopefully discussing what it is the city of Kenmore is dealing with, because then you would have a problem. To give you an example of where this went well and where this did not go so well. Just full disclaimer, I actually had a conversation with an attorney the other day, not about these cases, about a different case. And they called me and said, that's not what happened in the case. Well, what I know is what the judge tells me happened in the case. So this is the judge's explanation for what happened. But there has to be a collective intent for you to have a meeting. Up on the left-hand side of the screen, up in San Juan County, their planning commission was dealing with an issue, and 2 of the planning commission members were having a conversation. They looped in a 3rd council member via email and otherwise about what was going on. There's 7 board members, and attorney doing math, 3 is still below the magic line. What they didn't realize is that there was a 4th board member who had also been talking with that 3rd board member. So they inadvertently found themselves in a quorum situation. And obviously we know about it because it ended up in a lawsuit. When the Superior Court looked at this issue, because the Superior Courts enforced this the same way they enforced the PRA, the court said, I don't find that there was a collective intent to have a meeting here. And I think what really, my impression from reading the decision is what they did when they realized they had a problem. They stopped instantly. Because we do our best, and what happens next is, sometimes determines the outcome. I hope you never in this situation, but if you find yourself, you thought you were talking with 2 people and you're now all of a sudden talking with 4 people, you've crossed that quorum threshold, stop instantly. And that's what happened in San Juan. And I think largely that's why there was no collective intent for them to have this conversation. Versus, what the courts explained in City of Seattle versus in the Egan case. And you might recall the City of Seattle had a head tax a few years ago, and it passed on a Friday afternoon. And then on Monday, there was a repeal vote, and everybody was like, okay, what just happened here? And so in the course of the lawsuit, as the court explains, what they found was a series of communications between council members or their staff trying to figure out, what are we going to do? There's a huge public outcry here. How are you going to vote? And the court said, based on these communications, we think there was a collective intent to have this conversation offline. And part of it was polling. They were trying to figure out how were their other board members going to vote. Polling is not allowed. Votes have to happen in the open session, with maybe one small exception, and even that one makes me nervous. So think about any final decision needs to happen in this kind of a forum where people get to see what's going on. But it comes back to that collective, going back to where I started. There has to be a collective intent to have a meeting. So obviously be cautious of it, be cognizant of what you're doing. If you find yourself having, stepping up the line, or maybe even your toe over the line, stop and figure out, back away from the situation and don't go any further.
Councilmember Shevnik?
Just a quick question on
Of course.
polling. The way, and I just want to underscore what I think I already understand, but polling in this context is among each other. I mean, we, often get emails from our community, and we may not know that they're emailing all 7 of us individually. So, I mean, there's no way to know that.
Yeah, there is no way to know that. And all the cases that have talked about this in terms of this, where the city council, the county council, or something like that is trying to figure out, what are we going to do and that kind of thing. I'm not aware of any, I can't point you to any guidance on terms of talking with constituents. Well, this is how I feel. And then they go talk with Deputy Mayor O'Kane and say, how do you feel? Slightly different context. I'm not aware of that coming up. There does need to be action to finish off that definition. And going back to kind of what I've said a couple of times and implied it nonetheless, is that it's everything. One of my former colleagues used to describe it as people get to see the sausage being made. They get to see everything that goes into it. Whether that's good or bad, I'm not so sure. But that's the point behind the OPMA, is watching the public testimony, the discussions, the considerations, all those reviews. The final action is also part of, it's a subset of action. People get to see all of that, because like I said, as I started my comments, that's really where people get informed about what's going on, why it is that you all decide the way you do, and whether you vote for or against something. And whether it's an affirmative vote where you say, Mayor Herberg, how do you vote, yea or nay, or whether it's just a consensus building. Either one of those is final action. That is final decision making. Final action, whether positive, negative, collective decision making, whichever it may be, has to happen in the public sector. If you're in this public arena. Even if you can go into executive session, I'll talk about that in a couple minutes, for one of the permissible reasons, the decision has to come back into this forum in terms of whatever issue you're facing. Which is also, you need to be careful when you're in executive session, because sometimes it's easy just to keep talking. And that's where, police yourself, watch each other's back, listen to your attorney if your attorney's with you in terms of, okay, we need to stop now, please. Those kinds of things and whatnot. Secret ballots is a hybrid of polling. It's not allowed. Whatever your final decision is, people get to see what that is, whether it is that you take a roll call vote, or whether it's an oral vote, or whatever your decision-making process is. People get to see how it is that you feel on whatever issue is before you. I want to come back to the idea of public attendance. I mentioned this briefly as I started going, back to that core kind of idea. Only because we've seen some developments in this. It's unchanged that you can't put conditions on people's being able to attend. You can't make them sign up. City or the county of Yakima, I can never remember which one it is. found themselves in an OPMA issue when they went to a Chamber of Commerce meeting. It was a closed event. People had to buy a ticket, and then there was a majority of them talking about county or city business. That was an OPMA violation on a couple of different levels. But when I say you can't put conditions on attendance, where we've seen a little bit of change recently is, and this is also something that we learned coming out of the pandemic, was the legislation specifically allows agencies to put generally applicable conditions for protecting public health, safety, protect against interruptions. I'm not going to go into it tonight, but I could tell you about some really unfortunate events that happened in public meetings during the pandemic, just because of some, very passionate beliefs. And so the legislature allowed this, allows the agency to say, these are our general rules for generally applicable conditions, not focused at individuals. This is so new. There is no case law on this. My encouragement, folks, if you're thinking about developing these general rules, is great time to talk with your attorney. And I always, when I speak with people about it, talk about what's the least way we can accomplish what we do. If there is a, house of stone versus house of twigs way to get there, maybe the house of twigs way is a better way to get there. Aside from what the three little pigs tell us in terms of how to defend from the big bad wolf. Really approach it from the least restrictive kind of alternative. I think that's where you want to be. And again, there's this encouragement that we continue to use the remote access tools like we're using this evening. If you choose to, this is again, this current encouragement idea, there's also encouragement that you record the sessions, that you make them available on your website for 6 months, not a requirement yet. And it doesn't alter the record keeping requirements by the records retention statutes or the Public Records Act generally. There is an exception for schools, which I'll get to in a minute. So let's switch to the big change that really doesn't change a lot. This is this idea of public comment. It's now a requirement at every regular meeting in which final action is taken. And those are the two key pieces. The legislature could have drafted this differently. They could have said any meeting. They chose the words regular meeting, and I have lots of theories as to why. My best theory is because special meetings are things like study sessions happen that way or retreats happen that way. They still have to follow your notice requirements, but you may not be making final decision. It serves a different purpose. You have two choices as to how you accomplish public comment. One is oral comment, where people would have the opportunity to step up to the microphone. I still, you can put reasonable restrictions in place when it comes to this. Time and place in terms of, okay, we've set aside 30 minutes, 40 minutes, whatever the number is for public comment. Each person gets 3 minutes. I think you have people sign up so you know who to call next in terms of doing public comment. There's an expectation and requirement that if people can't make it to the meeting, either because they have a disability, mobility restrictions, or just general difficulty making it here, that if you can accommodate that, that's an expectation. I've seen some agencies with very little technology budgets literally accomplish that with cell phones, and they just have the person call the clerk of the board and they hold it up to the mic. Sometimes you got to be a little creative. But like I said, you can't put timelines. This is still a public meeting. You still get to have an orderly meeting. This does not turn it into a free-for-all. Your other option is that you can accept public comment in writing. Again, you can put reasonable rules in place in terms of the size, the length, when it has to be submitted. So if the council meeting was 6 o'clock this evening, you could say we need all written public comment by 5 o'clock on Friday. Something that gives the clerk of the board an opportunity to distribute it to all the board members, because that is a requirement. And then my recommendation is also for whoever is the council chair, as part of the opening colloquy, if you're doing written public comment, to put that on the record and say, we received public comment from 5 individuals. It was distributed as of 9 o'clock this morning. And that way it's documented. Part of the reason I recommend that is because when you're audited next time for your OPMA compliance, if you're doing that, the auditor's office will start looking for those bud phrases. Okay, prove to me you did it right. And that's just way you can, that way it's in the minutes and you should be good to go. There's some language in both the oral comment and written comment about being able to limit comment on items not on the agenda. If you choose to do that, I would recommend you talk with your attorney. Most agencies are, it's open mic. Some agencies split it between public comment at the beginning is on agenda items and the open mic is at the end. It's kind of how you want to do business, but if you're going to limit, I would recommend having a conversation with your attorney. I'd mentioned when it comes to that when it comes to taking public comment, it's regular meetings. So what are regular meetings? Regular meetings are those meetings that happen because this is what you've adopted in your rules. It says that we meet the first and third Mondays of the month at 6 o'clock at City Hall. It happens like clockwork unless it's a holiday, in which case, if it's a holiday, it maybe goes to the next day. In those situations, you have to have the agenda available online at least 24 hours in advance. With regular meetings, you can modify that agenda. I always encourage agencies and governing bodies to take that carefully, look at that carefully. And talking with my boards and commissions at regular meetings, I would always ask them, is this something we need to deal with tonight, or can it be set over for a special meeting or the next regular meeting? You can add agenda items and push them through to a final decision. The reason I encourage just a little bit of restraint is because when agendas start look very different, final agendas versus what was put out there, people start wondering what's going on. If I would have known they were going to do that, I would have participated or done something. There are some exceptions for very small agencies. City of Kenmore is far too large for that, so I'm not going to go into those. The next kind of meeting is basically every other meeting you could have. These are special meetings. These can be called by either the presiding officer or a majority of the council members. This is the one time in the OPMA you can have a conversation amongst yourselves. Be very careful not to talk about why it is you're meeting, but say we need to get together to talk about this issue. There are some specific notice requirements, 24 hours in advance. You have to give written notice of the time, place, the business to be transacted, the agenda basically. There is no exception if you can't get that notice posted with reasonable safety. This last year, the town of Lind was facing wildfires, that kind of thing where they couldn't get to City Hall to do that. There's an allowance for that. It has to be given to each of the council members. It can be waived by their attendance. It has to be given to the media, the newspaper, if they have a standing request for those. More and more, they don't have them because they're relying on what you put on your website. It also has to prominently be displayed both at the regular place of business and if you're going to hold the meeting someplace else, wherever that meeting is going to be held. What differentiates these from regular meetings in terms of the agenda is whatever you put out on your special agenda is the only things you can take final action on. You could add an action for discussion, but you cannot take final action on that. That's what makes it categorically different. The other thing to keep in mind is that your notice, your notice of the business to be transacted has to give people enough information to know what it is that you're going to be talking about. What is it that's causing you to have to get together on Thursday night to talk about this issue? And so people can determine whether they need to participate, come down, watch the meeting, tune in, whatever the case may be. We've seen a little bit of case law recently about how specific that has to be, but think about it in terms of, am I giving enough notice to the community that they know what it is that we're going to be dealing with? There is the third kind of meeting. These are emergency meetings. This goes back to the town of Lind I mentioned. It happened with a couple of other towns in Eastern Washington in the last few years. If there's a natural disaster that's pending, a wildfire, Mount St. Helens erupting back in 1980, those kinds of things, you can have a special meeting if there's going to be significant loss of property, injury to people, death, those kinds of things. In which case you have the authority to meet as fast as you can, get to do the business you need to do. The courts are obviously, as you would anticipate with these kinds of issues, very nervous about saying, oh yeah, go ahead and have these meetings. And they've looked at this in terms of economic loss. Pure economic loss is not enough. There was a school district that was going to have to extend their school year, and that was going to cost wages and things like that. The court said, that's not the standard. I've been practicing law for over 25 years, and I've never had a board or commission do this. I was talking with a utility district the other day, and one of the council members gave me a suggestion. What if it's like the water system is contaminated? Okay, that one I could get behind. That's if they didn't meet right then and there, somebody could get really sick. I could get behind that idea, but it's that kind of facts you're looking at. There is a new provision in the OPMA that lets the governing bodies have remote meetings to let us go back to 2021, like we ever want to do that. There is some specific requirements that have to be met. There has to be a declared emergency at the local, state, or federal level, and there are specific RCWs about who gets to do that. And then the agency has to determine that it can't have that meeting with reasonable safety, with either anybody present or with maybe with just the council present. If that does come up, If you over that threshold, again, I would talk with your council. You have to provide the opportunity to go back to 2021, so people get to be able to participate remotely. Tell them how they can tune in, at least be able to hear the meetings. Unfortunately, the legislature chose to use the word emergency in both of these. This is an emergency meeting versus a meeting because of an emergency. So you have to kind of figure out which lane you're traveling in, but that's kind of where we got. This does not change your ability as council members to participate in a meeting remotely if that's consistent with your internal rules. And you could conceivably have a meeting with all of you someplace else, but there would still need to be a physical location where people would be able to come in off the street, watch the meeting on the screen and be educated as to what was going on, watch the dialogue, that kind of thing. I want to switch gears for a second, and we're going to talk about everything up to this point is a requirement that meetings happen in an open session. People get to see what's going on. This is now the limited occasions when you get to take yourself out of the public view. These are called executive sessions. These can be part of a regular meeting, can be called for a special meeting. You can call a special meeting specifically for executive session. You still have to follow the process though. You are limited to why you're going into executive session into 4230-110. And this is a place where every board and commission I've worked with, I go back and I read the statute. And when we're putting out an agenda and because my chair of the board always has to announce, we're going into executive session for this purpose, use the language straight from the statute so there's no disagreement as to why you're going in, and that's a permissible purpose. When you're going into that executive session, the chair of the board has to announce how long you're going to be in. Once that number is chosen, you cannot come back into regular session early. You've got to stay out for whatever you said how long you're going to be out. If you need more time, again, the chair can come back in and say, we need additional time. I have seen this happen to a room full of empty chairs. It seems really weird, but it does need to happen. It also needs to be reflected in your minutes. It's now a requirement that the purpose of the executive session be reflected, but those nuts and bolts need to be reflected as well, because if you're challenged, you're going to need to be able to show that you complied. And also the auditor's office is going to care when they do their audit. When it comes to minutes of your meeting, all of the OPMA says, with the exception of the purpose of your executive session, it just says that you have to have minutes. It doesn't say what has to be in them. It says they have to be promptly recorded and open to the public for inspection. Most typically, that's the meeting minutes from this meeting would be approved at the next meeting rather. That's pretty common. I haven't seen a court say that's improper. Beyond that, it's kind of your practice. And I've seen some minutes that read like transcripts, and I always feel really badly for the clerk of the board having to do that. I've read a few that you can barely tell anybody was in the room. More typically what I see is issues minute, where you can tell people came, what the issues were, what the general conversation was, how the vote was resolved, what the decision package was. My suggestion is, if you're using remote tools to let people participate, have that reflected in the minutes as well. It just helps show the transparency. If you happen to notice how many people participated, great. But I just think it helps show that the agency is fulfilling its obligations. Not a requirement, that last piece, that's my personal feelings. I mentioned early on that I think we'll see more for recording meetings. There is now a requirement starting next year for school boards. They're being required to record their meetings, and I think we'll see more of this. I'm not going to spend a lot of time talking about it because obviously not a school board, but it is something that I think we will see. So it's something to plan for futures when it comes to that. Finishing off with the kind of the nuts and bolts pieces before we start talking OPMA penalties. These are still your meetings. Even public comment is required. That's not a change. The OPMA has a specific structure in place for dealing with interruptions, and it's a hierarchy. It's engage with the individual. If there's an individual that's causing the disruption, ask them to, your 3 minutes for public comment is over. Please, return to your seat. Maybe then if that doesn't work, you recess for 10 minutes. You have the ability then, if that doesn't work, where you can actually adjourn your meeting, and there's a specific vote process that has to be taken, where you can actually move the meeting to a different location. This is where, if you don't have it in terms of your board packet, hopefully, I recommend, talk with council. I'll have your clerk work with council in terms of building the hierarchy in terms of, so the council chair has the last page of the council book, a break in case of emergency. Step one is this, step two is this, because there was an agency in Eastern Washington that there was an individual who wanted to record a public meeting. These are public meetings. People get to record them. This is being recorded this evening. They didn't like that idea, and so they called the county sheriff, and the person was arrested. And that ended up in a wrongful arrest lawsuit and a judgment against the city. These are public meetings. People people do get to record them. That's not being disruptive. And I think that probably would have turned out differently if they would have had, the back page of the book say, okay, here's my first step. So give some hope it never happens, but have a plan in place so you don't get caught flat-footed. Finally, when it comes to OPMA penalties, this is where, unlike the PRA, which is agency liability, the OPMA puts liability on each individual council member, $500 for the first knowing violation, $1,000 for each subsequent knowing violation. On top of that, the agency is subject to paying costs and attorney's fees. Obviously, I don't want to see anybody in a situation where they're having to write that personal check. A judge says that you did this improperly. More concerning to me actually is the judge can also overturn what it is that you've done. If you take action in violation of the OPMA, a court could say to you, that decision you made 6 months ago, that wasn't properly done. I'm going to say that decision doesn't exist. Now go back and do it again. And so some of your decisions could end up in limbo. And I can think of a parade of horribles that, the repercussions from having a contract declared null and void, or having a decision declared that it doesn't actually exist. That concerns me actually more than the penalties piece, just from a longevity point of view, which why sometimes the best thing you can do when you're concerned about having violated the OPMA, you can't take away any prior error you may have made, but maybe sometimes the best thing you can do is independently yourself go back and say, I've got a concern with the way this happened. Let's go back to the beginning. Let's retrace our steps, make sure we don't have an issue so we protect the decision we're making from our inadvertent error we made. Court may not go back and say, if you did everything along the way, everything subsequent was fine, but that one very early decision wasn't. It's at the discretion of the court, but sometimes you want to insulate that if you're concerned about it. Again, great time to talk with your counsel in terms of, what's the best thing that we should do here. So with that is OPMA and PRA. I can answer any OPMA questions for you this evening.
Councilmember Lutzis.
Really quickly, you talked about the penalties and
Yes.
fines and things like that. Are there other ways to cure violations of OPMA retroactively?
The best way to cure it retroactively would be that, calling the do-over and going back and saying, okay, we think, and I was talking with an arts commission a while ago that was concerned they may have violated, and so they didn't want to have the problem with their awards of their grants. They went back to the first step and said, okay, let's reevaluate all of our applicants and move the whole thing forward again. It's that kind of insulation. You can't wipe it from the books, but you can effectively start chapter 2.
Thank you.
Any other questions on the OPMA? All right, I'm not seeing any. Thank you very much. We really appreciate this.
So thank you for inviting me.
It's a great
Appreciate it.
refresher. Next on the agenda is our land acknowledgement. We acknowledge that the city of Kenmore is situated upon the ancestral lands of the Snohomish, Snoqualmie, Sauksuatl, Duwamish, Stillaguamish, Tulalip, Suquamish, Muckleshoot, and other tribes who are part of the Coast Salish peoples. We recognize and express our deepest respect for their enduring stewardship and profound relationship with this land, which they have cherished and protected since time immemorial. We honor the First Peoples, acknowledge their vibrant cultures, and commit ourselves to learning from their wisdom in our journey to promote justice, equity, and mutual understanding. We pledge to stand alongside these communities in acknowledging past injustices and working towards a future that respects and celebrates the diverse heritage of this land. Now, if you would all please stand and join former Mayor Baker in the flag salute. Next on the agenda is agenda approval. I have heard from staff that item 10, the presentation from staff around our public records request update is not able to be presented today. So without objection, we'll remove item 10 from the agenda. We'll come back to us at a later date. Next up, we have one proclamation for Black History Month. Whereas we recognize, celebrate, and pay tribute to the many contributions of Black and African American people to the shared history, society, and culture of the United States of America. And whereas through bravery, perseverance, commitment, hard work, faith, and resolve, often in the face of prejudice and hardship, Black and African American people have enhanced and advanced every aspect of American life. And whereas for over 2.5 centuries, Black and African American people have struggled against the cruelties of slavery and Jim Crow segregation, as well as discrimination in social, cultural, political, and economic systems, and have faced disproportionate economic hardships and social inequalities. And whereas despite extraordinary human trials, Black and African American people have fiercely, passionately, lovingly, and courageously shaped American society and values through service, leadership, intellectual power, and the promotion of strong moral character in every walk of life. And whereas this nation is strengthened and enriched by people of every race, religion, color, and creed, this February during Black History Month, we celebrate the cultural heritage, diverse contributions, and unbreakable spirit and patriotism of Black and African American people. And whereas Black History Month summons every member of our Kenmore community to strive to build on our togetherness and cultural awareness, celebrate our diversity and intersectionality, and to create a future that does not compromise any American's right to equality or access in the quest for knowledge, economic prosperity, individual and collective achievement, spiritual development, and cultural richness. Now therefore, I, Nigel Herbig, Mayor of the City of Kenmore, on behalf of the City Council, do hereby proclaim February as Black History Month throughout the City of Kenmore. The Council makes this proclamation to celebrate Black and African American community and as an affirmation of the city's commitment to protect and serve everyone who resides in, works in, or visits Kenmore without discrimination, and of its beliefs in dignity, equality, and civil rights of all people. Next on the agenda is public comment. We welcome you all to the council's meeting. Please address your comments to the mayor and the council. You'll have 3 minutes to speak. If there are more than 20 speakers, time will be reduced to 2 minutes per speaker. The clerk will call your name when it is your turn. The presiding officer may choose to alternate between in-person and online comments. Please state your name and city of residence and keep within the allotted time to make every person feel welcome and safe here. Please refrain from booing, clapping, heckling, yelling, or other interruptions. The meeting is recorded for transparency. Thank you for being here and for sharing your input respectfully. Madam Clerk.
Thank you, Mayor. It looks like everyone's had the opportunities to sign up to speak. And at this point, we have 17 on-site guests and 2 virtual guests wishing to speak. Shall we begin?
Let's begin.
Okay, we're going to ask that when we call our guests in groups of 5, that you would line up behind the podium, please. Nathan McDonald, Kara Macias, Shannon Beatty, Leanne Atten, and Kevin Tomorsi.
Good evening, Nathan McDonald, Kenmore. I commend the council for listening to the community and approving option 3 in regards to the Plymouth Housing Project at the previous meeting. It is apparent that the 2 non-negotiable items, location and density, as well as the no barrier entry requirement, were the key sticking points that, without change, the community could not accept. It is further evident that the parties were likely biased toward the sunk cost fallacy that so often results in the continuation of a project that should have ended. Your courage and presumably recognize this is appreciated. So now the big question, where do we go from here? I submit that the community is clearly in favor of helping our neighbors most in need of assistance. It is my understanding that 3 even larger projects are moving forward that will significantly increase the affordable housing stock in Kenmore, which include roughly 150 family-oriented units behind Safeway, 175 units of senior-oriented apartments at the Jay's Cafe location, and over 100 units at what is currently St. Vincent de Paul. This is indicative that the community is striving to meet its requirements pursuant to HB 1220. For further solutions, I note the ideas posed by speakers at the last meeting to explore a relationship with Mary's Place. I believe it has a proven track record at helping those who not only have some of the greatest needs, but also perhaps some of the greatest vulnerabilities. What better way to improve the lives of our fellow citizens, including single-parent minor children, than to explore a possible development relationship with this organization? On another matter, it's time to reorder the city's priority list. The goal of making Kenmore a more desirable place to live can only be accomplished by increased economic development. Let's grow the amenities available to our citizens and those passing through, as well as our tax base, by fostering a business-friendly environment that encourages entrepreneurs to invest in the community. We all win when this happens. I don't have it written, but I observed a story in today's Seattle Times, which I think can apply quite well here. And that is that Mayor Bruce Harrell just announced a hiring freeze. What a great first step. Let's follow suit.
Mayor, council, deputy mayor. I work as a project manager. I work in projects of all scale, things that are close to this size as well as the Plymouth Housing. That has taught me is 1, projects change. 2, what did you learn from it? 3, how do you pivot? I've worked on projects where we've retooled, reworked, changed scope, changed the plan, got to a point where the plan just didn't work for anyone. It's okay, it happens. The heavy lifting and work to get there feels like a waste, but it's not. There's always lessons learned. Continuing to allocate resources, time, and expenses into something that isn't viable is a sign of commitment bias. Knowing when to face the facts, speak up, and pull the plug are signs of strong leadership. The goal always should be how to get from point A to point B, and for the most part, keep everyone included, informed, and on board. This is our lesson learned. Now, how do we pivot? Please hear us when we say this project was not the right fit, but that doesn't mean that one won't. Keep the plan for the town halls. This is important. We should do them regardless. Let's move forward together.
Good evening, council members and mayor. My name is Shannon Beatty. I've lived in Kenmore for 37 years. I think we can all agree that low-income housing is desperately needed and the need will only increase. I would like to see our city council return to a model that more closely aligns with the original concept of low-income housing, specifically for seniors, veterans, and disabled persons, all of whom are at higher risk than the general population for becoming homeless, a situation that cultivates and exasperates substance abuse and mental health issues. This in turn leads to the crime that we've all spoken about. Seniors and veterans are self-explanatory criteria. Define disabled persons specifically as persons that are legally considered disabled according to federal and/or state guidelines. They qualify for federal Social Security disability insurance or Washington State Medicaid, which is funded by DSHS DDA. Additionally, the new structure or structures should follow the current building code so that it fits into this community that we all care about. There are varied populations of unhoused persons, temporarily homeless, severely mentally ill, chronically homeless. Rather than trying to serve everyone by having low or no barriers, focus on a specific group or groups so that support can be personalized. Yes, you will have people with substance abuse and or mental health issues among this population, but that is not their defining feature any more than it is in the general population. We have residents who own their homes in our community and also struggle with these issues. The new residents could be people coming directly from homelessness, or we may prevent somebody in this vulnerable population from entering into homelessness with this model. Wouldn't that be great? Perhaps a percentage of both of those populations would make for a more balanced living environment. 5% of all homeless adults are veterans, and women are the fastest growing segment of homeless veterans. 30 to 40% of homeless people have a cognitive impairment, including traumatic brain injury, autism spectrum disorder, and intellectual disabilities, excuse me. So the need is obvious. But rather than bring a densely concentrated population with severe substance or mental health issues into a low or no barrier situation where they feed off of each other's problems, focus on the other criteria. Bring a diverse population so that those who are suffering can be surrounded in a more typical environment and potentially be lifted up. I believe the residents of Kenmore would embrace and integrate a low-income housing project for seniors, veterans, and disabled persons. We've heard loud and clear what a majority does not want. Let's start a conversation about what we do want and what we can do to address the homeless crisis. Thank you.
Thank you, Ms. Beatty. Leanne, followed by Kevin, and the next group, Roman Kesselman, Tom Cass, David Dorian, Patrick O'Brien, and Janet Quinn.
Hi, my name is Leanne Ayton, and I'm from Kenmore. Making the decision to sign a 50-year contract with Plymouth is a huge decision. If there are any doubts about adding 100 units of low barrier housing in our friendly downtown core, you need to vote yes on the ordinance to end the development with Plymouth Housing. Plymouth's low barrier housing means the chronically homeless, most mentally unstable, drug addicted, carrying a criminal background are singled out and given priority to live in Plymouth's low barrier housing complexes. Even though there are successes, if you look past Plymouth's shiny, well-scrubbed public image, there are some problems. Once our council signs the contract with Plymouth, what recourse do we have when problems arise? Can we legally take action against Plymouth Housing Group? Probably not, as Plymouth's literature states, the city of Kenmore is responsible for public safety. Kenmore's police and fire now hold the burden to respond to the problems created by the low barrier housing. Can a citizen hold the city of Kenmore liable if they're assaulted or harmed or harassed by a Plymouth resident? What happens if there's a fatal stabbing? How do we ever restore the safety lost in our downtown corridor? Must Kenmore choose between low-income housing and safety? Kenmore residents are generous. We are supportive of low-income housing, just not at the expense of community safety.
Council, Mayor, my name is Dr. Kevin Tomaresi. I've been a resident of Kenmore since 2016. I want to thank all of you for your service. I know that it's not easy. I'd like to thank our city staff for everything that they've been involved in, because I know that this has not been an easy process for them either. I'd first like to remind the mayor that you do have a conflict of interest in matters relating to Plymouth Housing. You work for the King County Housing Authority, and that does put you in conflict. You should be recusing yourself from all matters related to this issue. I would like to say that we who oppose this project are portrayed as NIMBYs, hate mongers, or afraid of change, and we are none of those. We care about the city, want to help those who live here, and want to be part of our community, want solutions and accountability. We want partner agencies and programs who are honest, open, and actually help those in need in our community. We want to maintain the safety and vibrancy of our community while promoting equity and helping those who genuinely need it. In future decisions, the City Council and staff should promote projects widely and seek broader public input, recuse themselves when there are apparent conflicts of interest, and not accept hasty last-minute changes such as those that occurred in the Plymouth project. We love our city and our community. We want to help those in need, but it must be done in a way that is responsible and protects everything that we have built here. Thank you for your time.
Roman Kesselman, followed by Tom Cass, David Dorian, Patrick O'Brien, and Janet Quinn.
All right, dear Mayor, dear council members. Reason I came here tonight is I've been following up on this Plymouth project for some time. And I felt that sometimes you have people who've spoken more than once, and I wanted you to get a sense of just how much of an opposition there is to this Plymouth project. Respectfully, it's a lot more people than perhaps is apparent. And I've lived in Kenmore since 2015. We bought a house in this beautiful little town. We have 2 children. They both go to local schools. So what happens in this town is very much important. besides the fact that we enjoy this downtown and how it's been developing in the Stoop where I just went, as well as Diva Cafe where I go to get pastries in the morning. We want to keep it a safe place for the community and for the children in this community specifically. So I'm a little bit familiar with housing authorities in King County and local cities as well. Yes, the people who live in subsidized housing, they need help. And a lot of it is because of mental health issues. And from what I hear is there are things that come up all the time where the police needs to get involved, where medical services need to get involved. We're just not well suited to have it right in the heart of our downtown. But what should not be overlooked is that a lot of people living in these subsidized communities still possess firearms. People, mentally health challenged people with issues, however, cannot be denied their Second Amendment rights. And I think that brings a particular concern to me as a parent and as a resident of this town. So the location is not right. The services that we cannot provide to these people and cannot be made as readily available as if they were in a larger community. We respectfully ask you to stop this project and reconsider our options and the way we want to develop this downtown. There's a lot more opposition that may be apparent to you, but citizens all over Canmore are all up in arms, frankly speaking, about this project, and we just do not want
Thank
it
you.
the way it is
Tom
presented
Cass.
in our community. So thank you.
Hello, Tom Cass, nearly 10-year resident of Kenmore. I appreciate the council listening tonight. And I thank you for listening to the overwhelming opposition to the Plymouth project. I understand that many of us here, many of the council have listened to different thoughts along the way, but I urge you to adopt the ordinance at hand that will deny this project. And I want us to start looking forward now. I'd like to talk to the council about what we can do going forward. And what we can do going forward with a property such as this that was considered, perhaps a children's museum, maybe a learning kitchen on the bottom, enriching young lives and providing meals delivered perhaps to the homeless or even the seniors or disabled of this community. This is something that can benefit us all. And I think that the community will be stronger from it. And inclusive in that is the ability for the businesses around the area, our downtown area, to thrive and continue to grow, which is what we've seen here in the last few years from some of the great work that's done. Thank you for listening tonight.
David Dorian, Kenmore. Mayor and City Council members, tonight you will vote to deny the Plymouth Housing Development Agreement. Not only that, some of your comments last week suggested that this is the end of any attempt to build deeply affordable housing on the Shell property. My comment is not an attempt to change your mind. It is to look to the future. There are different ways that you can exit from this project. Some paths do so in a dignified manner and retain relationships with key partners, city staff and residents, and other paths do not. I am commenting to ask you to choose the dignified path over the path of recriminations to save political face. Speaking to council members who have served since 2021 or before and voted to deny the development, council members Marshall and Srebnick and Deputy Mayor O'Kane. The dignified path requires that you acknowledge your errors that allowed the project to get this far when it was, by your own words last week, so inappropriate for the location. You approved the location in November 2021. The 80 to 100 unit density the RFP was structured for, the goals of the RFP to prioritize deep affordability, and then you approved Plymouth's bid meeting those RFP requirements after 3 separate presentations in April to June 2022, including an entire special meeting devoted to the proposal. To say, as you did last week, that the site and the density are now a fundamental issue is inexplicable in that context. Go back and watch the sessions in May and June 2022. See how clear the presentation about the RFP response was. See where you failed to ask questions at the depth necessary, a depth that only hit its stride last week, over a year into a partner investing time and precious financial resources into the project, not to mention the impact of staff time that could have been saved. Don't try to make Plymouth take the fall for this, and don't try to put it on staff. You are our leaders. Good leaders take responsibility for their own failures. It's time to step up and do that on this issue so that more harm isn't done to the cause of deeply affordable housing in our region. And then we've got to immediately get back to work on securing low-income housing in Kenmore via other options. We all hope for many, many more affordable units at the Whole Property, Jay's Cafe and St. Vincent's de Paul. But the reality is that none of those projects are shovel ready and none of them have 30% AMI or under units as part of their construction. As of tomorrow morning, there will only be one unit at 50% AMI or under on the list of city's current projects, alongside 75% AMI or under the other 4 affordable units at Beechwood 2 apartments. I also believe that no deeply affordable housing at 30% AMI has been caused to be built in Kenmore in the past decade. Please fact check that if that's wrong, but I couldn't find any evidence of it. And that there's now no pipeline for it at any stage of development. At the same time, the deeply affordable housing we have tried to protect has become less affordable to residents, several of whom have become sick due to the related stress of that. You've got urgent work to do. You must end this saga in a dignified manner in order to do it. Thank you.
Good evening, Pat O'Brien, Kenmore. Thank you for your votes last week. I don't know why we were in such a nosedive with all the people that were here. How hard was it to extract a vote that the people fully endorsed, which was to end the agreement with Plymouth House? What I am in favor of, now that we have that property available, I want to see a new Thai-Ho restaurant. I'm demanding Chinese food. Thai-Ho left town. We need to have more restaurants and things that'll make people actually pull over and buy something in Kenmore. We don't need to hang our laundry on the main street. We need businesses that people will drive by and go, oh, that smells so good. I want to pull in and get me some of that. I don't care if it's barbecue. I don't care if it's Thai. I don't care if it's hamburgers. I don't care. Salads would be fine. But put something there that will attract people to stop in Kenmore and go, that's a yummy place to go. That's it. So the next thing I'd like to point out is we've wasted $30 million on the new maintenance facility. Believe it or not, it was a flawed process. People gave bad testimony and recommendations and didn't do a full evaluation system that would hold water at all. And I'm encouraging our mayor to investigate that and see if we can change course, because wasting or spending $30 million on something we could have provided for the community for $3 to $5 million in the old fire station is worthwhile looking into. So we need to look into it. We also need to know who are all the owners of Lake Point. We need the LLCs, everything we're involved with out there. We've made a commitment to the Native American tribes and we're stewards of that. But I've seen no evidence of shutting down the stinky asphalt plant, the noise, the hours of operations on weekends at all hours of the morning. We've seen no enforcement of those things. We've seen no real testing of the water. We've not seen any testing of the land there. And on the city website is a whole thing on Lake Point, but the one document that they don't show is Washington State versus Pioneer Towing, and what the summary judgment was signed by the property owner, Gary Sargent, and the state of Washington Supreme Court. That's not on our city records for some reason when we're talking about Lake Point. Let's change that. Thank you for the vote last week. It was a real nail biter. Thank you.
Janet Quinn, followed by Laura Hodge, Dan Troyan, Joe Nance, Tom Herman, and Chris Olson, please.
Janet Quinn, Kenmore resident, staff, as you all know. I am here not to ask you to pull that item off the consent agenda, but to beg you not to. There's a verse in the Bible that says, out of the abundance of the heart, the mouth speaks. And what I've heard in the last several meetings has me standing before you brokenhearted. People have said, I'm in favor of affordable housing. And the rest of the statements that they've said have been, don't let it affect me. Don't put it anywhere near me. Don't put it where it will affect anybody around me. And I just find that so disheartening. I would have loved to have seen somebody say, we have a lot of dentists in this town. We have a recognition that people who are homeless have an experience that probably doesn't include a lot of dental work. Maybe we can help them. Maybe we can demonstrate to the community how we can be coming alongside them and supporting them. So I'm hoping that we will have from this a conversation, real conversation about affordable housing and what it is, about homelessness and how you can come out of it without community surrounding you and without people supporting you, what 30% AMI looks like, how you survive on that when all of the people around you are saying, yeah, you know what, you're not welcome. I'd rather have a restaurant that smells good around here, but please don't let us have somebody with affordable housing needs. So I don't even know what to do with this. I am so literally brokenhearted by the community that I know and that I thought I knew better. I'm hoping that future conversations will reveal that we really do have a heart for people that are less fortunate than we are. And I'm hoping that you will demonstrate leadership and ask hard questions and ask thoughtful questions and be respectful to our community partners that come up alongside of us to do these projects. So I expect a lot of you, and I look forward to hearing the future conversation around this topic.
Good evening, City Council. Laura Hodge, Kenmore. I want to thank Kenmore City Council for going with option 3 at the January 18th meeting to reject the Plymouth project. We appreciate the council for listening to our concerns and doing the right thing for Kenmore by stopping the Plymouth housing project. As a final step tonight, we ask you to please adopt ordinance 24-0605 that will formally deny the Plymouth agreement altogether. We need affordable low-income housing in Kenmore and have said this all along. Kenmore has a small city budget, so we need to act with fiscal prudence and be very realistic about what a small city can handle. To that effect, I would like to see more ongoing engagement between the council and the Kenmore community through an increase in avenues like coffee with the council and town halls. In fact, I learned that the last coffee with the council had 25 citizens in attendance, and that's pretty darn good. And I'd like to see that going forward as well as town halls, because there are people that may feel uncomfortable about coming into a civic auditorium and facing the council. So let's keep that momentum going for the coffee with the councils, town halls, really like that type of engagement. So I appreciate you taking the consideration for that. Let's work together in full partnership and transparency. I mentioned last time, let's look into Mary's Place. I think we could really build something upon that organization in public and private partnerships. And I think there's a lot of ideas to be had there. So let's take a look at that. Thank you also for what we're trying to do. We're trying to build solutions. So let's work together, and so we can really achieve what we want to achieve with the city. And lastly, I want the city council to really look at the priorities again, because remember, we're coming out of a COVID pandemic. And a lot of businesses have really suffered economically Businesses are vital to bring in tax revenue. So let's kind of bump up that economic development priority to the top 3. Again, thank you very much for your time.
Hi, Council. Dan Troy and Kenmore. 3rd time's the charm. Here we go. No, but seriously, to echo what others have said, thank you all for being here. Thank you to the staff. Thank you for the people coming out again to speak up for what you believe in. It's appreciated regardless of where you are on this topic. I also would like to echo that we need to continue with the town halls, with the engagement that I think is pretty unprecedented with this topic, and let's keep it moving forward. It's great to see so many people out here to hear about the coffee with the council and how many people showed up to that. That's great. I would like to remind you that the sunken cost fallacy is a real thing. And the council, along with Plymouth themselves, admitted they were getting new information as early as last week. So when people bring up November of 2021, things have changed since then in terms of public perception, in terms of what Plymouth has said, in terms of your understanding. There are just new council members that ask really great questions, regardless of what former members of the council like to say on Facebook. I think we know who we're talking about. No laughing. Sorry. So moving forward with the 3 new projects we have for affordable housing, I think that's really great. I think those are 3 great options. Not exactly the same as Plymouth, but they'd get shut down if they were. So let's be happy for that. And I look forward to more community engagement and working together on those 3 projects specifically and getting those, completed. Anyway, thank you.
Hello, Mayor and City Council. Joe Nance, owner of Lake Washington Physical Therapy on the corner down there on 181st, and resident Kirkland. I'd like to thank you all for taking into account the testimonies the last 2 public meetings and a decision that you probably came to with a lot of frustration and after a lot of hard work, a lot of sleepless nights, a lot of resources and a lot of discussion you guys put into getting to this point with that project. And I thank you for listening to all of us and understanding where the community is coming from. And that's that it's the scope, it's the size, and it's the no barrier to entry that is the biggest sticking point for a majority of the community, including myself. I look forward to different ways that I can get involved as a person and as a business to help the homeless in Kenmore. And I look forward to seeing what kind of opportunities those are. And I'd just like to ask you, as you go to vote tonight, that you continue to consider the risk, real or perceived, of what it would be like in that part of the city if you were to move forward with this project, and the risk, real and perceived, to the businesses in that area. We'd all love to think that everything's gonna be fine and there's gonna be great patronage and with 200 possible plus people coming to that area. But there is some real risk, and we've had several people testify as to those risks, police officers, community members, people that are involved with these different types of projects. So I just ask you, please consider that, and just consider the risk to business owners in this area that have had to come out of the pandemic, that had to accept PP loans to stay afloat, that have done everything they can to keep fighting to get through this time, and to do the best to serve the community of Kenmore as much as possible in the best way they can. And as a business owner, you have to mitigate your risk as much as possible in order to be successful and to be able to provide income for your employees. And this could be a real challenge for us if this was to go through. So I appreciate all your hard work. I appreciate you listening to us. Thank you.
Thank you. Mr. Tom Harmon has declined to speak, which leaves us with our final 5 guests: Chris Olson, followed by Richard Lewis, Jeff Stockamp, and virtual guests Tracy Benishinsky and Stacy Valenzuela.
Good Good evening, council and Mayor. I don't think it's a secret I'm disappointed, but I understand many folks behind me disagree. I do want to echo the statements both from people who I have disagreed with in the past and agreed with, that we need to continue dialogue. I think town halls are an effective way for that, and I'm glad to see so many people that spoke against it here tonight speaking in support of continuing this. While I am concerned, given some of the statements I've heard, things about last minute changes and the like, I think what I find frustrating is points that are emphasized most is what people disagreed with are points that we knew since the beginning, where we had 12 meetings from Plymouth, not get this engagement until now. And I would like to continue this engagement as such, so that way hopefully this does not happen in the future. But I am also concerned that 30% AMI housing will continue to be put on the back burner or excuses have made for it. We have other housing projects and those are important. They are not for the people who need it most. I wouldn't say they don't need it. They definitely do. Housing costs in this area are quite expensive, but I want to note that. To me, many of the changes that have been discussed as being deal breakers that are not related to density or location include things like 100% disabled, when we knew from the beginning the Plymouth population on average is 90% disabled. So 90 to 100%, that's a 10% change. There are others, but something I simply wanted to note. Yeah, so I'm really glad to see these folks here tonight. I'm really glad to hear people requesting town halls. I think that's important. I think this process needs to continue while there is momentum, as others have stated. And hopefully in the future, we can ensure more trust with our partners. That way they don't invest money that is not ours to something that ends up failing. That is hard when we're going and looking for funders, especially for things like 30% AMI. Fiscal responsibility has been brought up. 30% AMI and below housing is incredibly difficult due to its cost. And just cost, it's expensive, especially if you're going to be building on contaminated sites, which we likely are. Grant money is really important for that. So we're going to have to work with people outside of Kenmore and we're going to have to figure that out. Thank you.
Richard Lewis, City Kenmore. Thank you, Mayor Herbrig and council members. With ordinance number 240605 on the docket, I want to make a few comments about some of the line items. Based on the vast majority of public comments that we've heard regarding Plymouth, a few of these line items stand out in particular, address the core issues. I can paraphrase them. The City Council, I believe, has found that the location, size, and scale of the proposed Plymouth housing project and the departures from the city's development standards, such as increased density, reduced setbacks, and reduction in parking, will have negative impacts on the downtown commercial zone surrounding the community. And the other line item I want to mention is, paraphrase it, the City Council has found that disapproval and denial of the development agreement is necessary for the health, safety, and welfare of its residents and businesses. Thank you.
I am Jeff Stockamp, resident of Kenmore. I just want to thank you for listening to the community last Thursday and voting to disapprove the development agreement with Plymouth. I think you saw some of the challenges that the community had been dealing with in regards to conflicting information from different sources and answers that change significantly from one meeting to the next. We simply cannot take on a project that would shape our downtown core for 50 years with that degree of ambiguity. Particularly, I want to thank Councilmember Lutzis for his direct and clarifying questions. Your questions checked dangerous assumptions and showed that you were well prepared and had done your homework, contrary to what some people said on Facebook. You directly surfaced what the important issues were, and I'm looking forward to your leadership in city government. So thank you.
Mayor Herbig, that concludes our on-site list of people who signed up before the public comment segment began. Would you like to entertain additional comments, or shall we move on to virtual comments?
Let's go to virtual comments.
Okay. At this point, we'll hear from our pre-registered virtual guests, Tracy Panishinsky and Stacy Valenzuela. Ms. Valenzuela, can you hear us?
Yes, can you hear me?
You can, go ahead.
Thank you. Stacy Valenzuela, Kenmore. Thank you for deciding to deny the project from Plymouth Housing. Supportive housing is not affordable housing. We need extremely low 30% and very low 50% affordable housing. I am beyond disappointed that this will take longer and more of my neighbors will likely be adding to those living in the encampments, their cars, and outdoors. However, being abused, attacked, and dying from fentanyl or meth fumes is not a solution, no matter how much sympathy others have for those that choose the life, get hooked on that life. It's not a right fit. I think transparency in regards to what affordable housing is, the catchphrase does not include really 50%, which is workforce housing, or 70% that is moderate housing, or 80% that is market rate housing. I do not see any other projects other than the one at Hoyt with Habitat for Humanity and Imagine Housing with the Hope Link facilities. So I think we need to also talk about that. I think why we would take the hope away from our local residents that are homeless or on the brink of, to bring a dumping place for Seattle, Lake City, shoreline cases here is beyond I could even comprehend. I hope that you will consider going forward with another 30% housing project. There is a lot of grants out there. They just released another 312 million. We can do this. We could do better. And I hope you look at the past and think about doing better. Thank you very much.
Thank you. Tracy Panishinsky, can you hear us?
Yes.
We can hear you. Go ahead.
Tracy Panishinsky, Kenmore. I come before you tonight to speak on the Plymouth Supportive Housing Development Project in Kenmore. I come not with the expectation that the development agreement would be approved, but with gratitude for the incredible work of Kenmore City staff. They worked tirelessly at council direction to move this project to fully funded and shovel-ready in under 2 years. This is an exceptional achievement by any standards, and I want to thank them for their dedication, heart, and hard work to make Kenmore a place where everyone can have a home. While the project will not come to fruition, that they care so much matters. We are lucky to have them serving our community. Mayor Herbig, thank you for standing by this project through the end, especially considering the ad hominem attacks and vitriol you had to endure. Council members Culver and Sasson, thank you for seeing the merit of permanent supportive housing and being open to the possibility that our community could thrive with it. I would like to share the words of Jim Rigby, pastor at St. Andrew's Presbyterian Church in Austin, Texas. He uses some strong language. If it hooks you, I hope you will work to hear past it to hear his important message. We believe we can vote our wallets and that we bear no collective responsibility for our human family. While we may be generous as individuals, we do not allow the redistributions of goods that would move us from individual charity to collective justice. We may long for a fairer world. We may even pray for it, but our allegiance is to a political and economic system that leaves us the ethical equivalents of pickpockets. Solidarity is not pity for other human beings. Solidarity is the sanity to realize the lives of every human being, animal and plant, is interwoven. We will not be saved by the empty platitudes of preachers telling us to love one another in principle, even as we serve as cogs in the death machine of economic cannibalism. No, solidarity must be put in practice. Solidarity is not the wispy mirage of some future utopia. Solidarity is the steely clarity of vision to realize the earth is one ecological whole. I love Kenmore so very much. My hope moving forward is that we can come together as a community with all of us, including each of you, being accountable for our part in how this project fell apart so dramatically, and find ways to make sure it doesn't happen again in future so that we can be a place where everyone is welcome and where everyone can belong. Thank you, as always, for your service. I appreciate you all. Thank you.
Thank you. Mayor Herbig, that concludes our virtual speakers list.
All right. Thank you, everybody, for coming and participating. We will get to that in just a second. But first, Mr. City Manager, where is the fun?
Excuse me. All right, well, we've got some slides showing yet another love note produced by Maura Query it was on Martin Luther King Day. It was thoughtful citizens picking up litter on and around Log Boom Park Beach, the park itself. And I think they had about 45 volunteers signed up and show up, and they collected about 170 pounds of garbage that day. So it was just a really wonderful day. Cold, it was really crisp that day, but it was a beautiful thing to see it come together with all the people volunteering and pitching in. So that's the answer to your question. Where's the fun?
Thank you very much. All right, next on the agenda is the consent agenda. The chair would entertain a motion to approve the consent agenda.
Mr. Chair,
Councilmember Culver.
I move to remove agenda item C from the consent agenda.
Okay, that doesn't require a motion. Any one member can pull something off. So we will, sorry, which item was it? Item C? Item C is removed from the consent agenda and will be considered right after the consent agenda. The chair would entertain a motion to approve the consent agenda minus item C.
So moved.
Second.
We have a motion and a second. Any discussion? Seeing none, all those in favor say aye.
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 Any opposed? The consent agenda minus item C stands approved. Item C, ordinance number 24-0605, disapproving and denying the proposed development agreement for real property located at 6532 Bothell Way Northeast. Mr. City Manager, did you want to?
I think, as we all know, this is a result of last Thursday night's council meeting, and so an ordinance denying the development agreement is in front of you. The agenda bill talks about the different hearings that were held. And the ordinance has the whereas sections explaining the reasoning for the denial.
Do we have any questions for City Manager before we move the ordinance? Okay, the chair would entertain a motion then to adopt ordinance number 24-0605.
So moved.
Second.
We have a motion and a second. Is there any discussion on the agenda item? Okay, with that, would the clerk please take the roll?
Thank you, Mayor. On the motion to approve ordinance 24-0605 to deny the development agreement for real property located at 6532 Bothell Way Northeast, Kenmore, Washington, 98028, between the City of Kenmore, Plymouth Housing Group, and Kenmore Housing LLC. Councilmember Marshall.
Yes.
Councilmember Culver.
No.
Councilmember Lutsis.
Yes.
Councilmember Shrubnik.
Yes.
Councilmember Sassen.
Yes.
Deputy Mayor O'Kane.
Yes.
Mayor Herbig.
No.
With enough votes in favor, the motion passes and the ordinance is adopted.
Your Honor. Just for the record, I just want to confirm for the record that it was 5 votes in favor.
Yes, it was.
Okay, just want to get that on the record.
All right, staff report. Do we have any staff reports?
No, Your Honor.
Council member reports and comments. We have one item here, and that is our regional committee assignments. In the packet, there was I'm just bringing it up really quickly. is it? Attachment 1 shows the 2023 council committee list. I'd like to go through this really quickly with folks, and we can talk about where we have absences and where what interest people have in filling those absences, or if anybody is a sitting member of one of these committees and wants to change committees, they can let us know and we can find folks to fill that in. So first on the list is the East Side Transportation Partnership. We have 2 positions on that one. I am one of the members. I was actually chair until earlier this month. And then we had Councilmember Kugler and Councilmember File as an alternate. We do need a second. We do have 2 voting seats there. I'll run through all these really quickly and then we can talk about it. We also have the Seashore. So ETP and Seashore kind of related committees. We also have ETP kind of covers from Kenmore going east and then kind of south on the east side down to Bellevue-ish. Seashore is a similar sort of transportation committee. It is us, Lake Forest Park, Shoreline, and the city of Seattle, along with, there are also some members from South Shoreline, Snohomish County that join. Deputy Mayor O'Kane is in one of the positions that we have, and then we have a vacancy and we don't have an alternate there. We do have a seat on the Public Issues Committee for the Sound Cities Association. We don't have anybody there. We had former Councilmember Baker as our voting member and former Councilmember File as alternate. I have an interest. The mayor has usually been the voting member there. I have an interest in taking that position unless there's any major objections. Then we also have RIA 8. We have 1 voting position there. Deputy Mayor O'Kane, and we could use an alternate if somebody's available. And then we do have the North Shore Parks and Recreation Board. We have 1 voting position. We have Councilmember Shrebnick, who I believe is currently chair of that. So with that said, I'd just like to run through these, and if folks want to express their interests, that'd be great. Yeah, Councilmember Shrebnick.
I don't know where this committee sits, but the North King County Coalition on Homelessness. I mean,
Yeah,
we usually
the
have
Nusha seat. Yes, we do have that. Thank you for
Well,
flagging that.
that's different. That's also, but the Thursday afternoon monthly North King County Coalition on Homelessness, we usually have I've been representing, and we also have a staff person.
Were you gonna continue on that, or?
I'd like to hand that off since I took on another SCA committee, but if nobody's interested, I could hang on to it. Yeah.
We will do that, and we'll also be discussing, we got an offer from the North Urban Human Services Alliance to have a city council member sit on their executive committee, and they were hoping for us to send them somebody sooner than later. So starting off with ETP, covers transportation issues, Metro, Sound Transit, WashDOT, all sorts of exciting stuff. Does anybody want to be a second on that one? Councilor Lutzis has interest. Does anybody else? Okay. Let's add Councilmember Lutzis to ETP. Next is Seashore, where we have Deputy Mayor O'Kane, but nobody else. Does anybody have an interest in Seashore? Okay, Councilmember Lutzis, I appreciate that. I will warn you, these meetings are back-to-back 2 different Friday mornings, and a lot of the time you'll get the same presentation 2 weeks in a row.
My Friday mornings are open, and redundancy always helps.
You really do learn the lesson the second time around. Plus you come up with better questions to ask. SCA Public Issues Committee, I would very much like to be the voting member now, unless there's any objection, and then we do need a alternate for that. Deputy Mayor?
Yeah, I'd be happy to be alternate for that.
We all okay with that? Okay. Just taking notes on this. Riot 8, Councilor Deputy Mayor O'Kane, do you want to continue in that? Okay.
Yes.
MPRSA.
Oh, we do have a council member that would like to be an alternate.
Yeah, interested in the alternate.
Great, wonderful. NPRSA, we have Councilmember Srebnick, but no alternate. I assume you want to continue on that because you are the chair. So do we have any interest in, does anybody have any interest in serving as alternate on NPRSA? Councilmember Lutzis, okay. And then, yeah, as Councilmember Srebnick pointed out, we do have the North King County Coalition on Homelessness. They meet, is it monthly, Councilmember Srebnick?
It is. It's a Thursday afternoon, and I want to say it's like 1 to 2:30, I think.
And then that committee has a council member from all of the 5 North King counties, like Woodinville, Bothell, Lake Forest Park Shoreline, and then also has human services staff from
Exactly.
those different, okay. Councilmember Sassen, you're interested in that one? Wonderful. Okay, and then next we have the North Urban Human Services Alliance. They also meet during the day. You want to be on that? Okay, wonderful. That was relatively painless. All right, on to just regular old council member reports and comments. Council Member Culver.
Yeah, I got a couple things. We heard it here tonight. Council needs to pick up the ball on affordable housing for lower AMI levels, certainly rather after requisite naps, vacations, what have you. That's all certainly in order. Even community members who are vocally opposed to this particular project said it themselves that they support homeless housing projects. In my view, this presents a great opportunity for council because the homeless population needs our help and our collective vote did not give it to them. So let's do talk solutions. I would broadly propose we draw from many of the elements from option number 2, spread out the community engagement plan, town halls, mail, put together an advisory board like we have for climate and financial sustainability, give every resident an invitation to make their voice heard on this, put it to a vote. Homelessness is an emergency right now, so let's facilitate a path forward to making it work for those in the community who do want to engage in the problem-solving process. And moving on from the development agreement itself, I think option number 2 lays out a pretty solid outline, which maybe we can take up on a less condensed timeline. This directly supports council priority number 1, increase and preserve the options of affordable housing, and I would love to have a second.
Councilor Marshall.
Thank you. Thanks everyone involved, our staff, our council, and most of all our public for coming out for these meetings. Please stay involved. And I'm going to make a big risky ask here, whichever path we decide to take, help us get a public pool within some reasonable distance from Kenmore. You got to help. You got to help. We need your help. Thank you.
I would remind council members they are supposed to direct their comments towards the chair, not the audience, as we discussed at our training last week. Councilmember Sassen.
Mr. Mayor, I'm hearing from this group repeatedly that the location, the density, the low barrier were really the pivot point from the previous council having supported this project to this council voting otherwise. I feel very strongly that this amount of engagement is what's necessary for what comes next. I don't have all the information about the projects that are in the pipeline, so I imagine you don't either. And so I don't want us to jump to conclusions about what they are. I think we need to have town meetings, town halls, in order to all be clear about that. But I also need to be clear with all of you, which is that I was raised to believe that privilege begets responsibility. And we will not, as long as I'm sitting on this dais, be neglecting our responsibility to those who have less privilege than we do. I believe in lifting all boats, and I believe in promoting our collective humanity. And that's what I have to say tonight.
Councilor Srebnick.
A couple of things. Joe, thank you for the great segue. At NPRSA, we actually, so dialing back, not everybody saw earlier in the month, we had a presentation of a pool siting study. And because neither of the sites particularly served Kenmore very well, we had directed staff to look to the North Shore School District boundary area, the NPRSA boundary area, which is the same, to see if there were some options. And so that is being studied, and there will be a community and youth activity center and activity survey that will be going out district-wide. And it will include questions about a pool. So, and I think there is a potential path forward, but certainly our community and all of those in the North Shore Parks and Recreation Service area will need to be engaged in that, should that come to pass for the next levy renewal, which is in 2025. On to the other topic. Just want to again reflect my gratitude to staff for their tireless work on the Plymouth project, Plymouth staff, and, importantly, our community. This was obviously unprecedented engagement that we had, and I for one, really appreciate it. I think we all do. I concur with many in the audience and folks that have already spoken that, we are not off the hook. We need to provide solutions for our unhoused neighbors, full stop. This might not have been the project, but that does not take us off the hook. I have several ideas about how we might move forward, and I hope that we can continue engagement in town halls, and I would like to make a motion, and if seconded, I'll speak to it, to have a discussion at the next meeting where that is feasible, to discuss the creation of a homelessness and housing community advisory panel.
Second.
So that's the motion. Yeah, thank you.
All right, we have a motion and a second. Councilmember Shomik, do you want to speak to your motion?
Mr.
do.
Mayor, I apologize. May I speak?
Yes, of course.
So this is a special meeting.
Oh, that is correct.
And accordingly, unless it's been on the agenda, final disposition cannot be.
Right.
That is a very good catch.
So how do we bring up topics that we want to have at a next meeting, since we're not having another regular meeting for several weeks?
You'll have to probably bring it up at our next regular meeting.
Okay, it's just trying to capitalize on the momentum, sorry.
Thank you.
All right, well, okay, we won't be doing that. I will just say one more thing that I feel like we have not examined, explored who really are the folks who are homeless and in need in our community. We frankly don't know how many folks who are single adults, how many folks that are families, what is the distribution of needs among those populations. I don't know how we would craft something would work unless we know what the needs are. So that, in my opinion, would be the first step.
Councilor Lucis?
Not too much to add, Mr. Mayor, just that as we've seen tonight, there's a lot of support for alternatives going forward. There's a lot of momentum when it comes to supporting our unhoused neighbors from within the community, within the council, continuing with community engagement and involvement, town halls, to figure out how we can best do that, to bring about support so that everyone is on the same page, I think is, the blueprints and the plans for moving forward. So I just want to, express my gratitude to everyone involved for all of the time and hard work, from community to staff to everyone here and everyone who's not here who did a lot behind the scenes. It did not go unnoticed. I can promise you. So that's all I have to say. Thank you.
Deputy Mayor?
Yeah, I've got I think
two or three items that I wanted to bring up that are related to our discussion today and what's upcoming. So, and I recognize we can't make a motion or a second here, but I do want to make the suggestion that we make some serious adjustments to our retreat agenda next week, because we are listening to our community, and it is time for us to, especially with the new council, look at our council priorities. I think it's incredibly important that we do this sooner than later. We have come through the pandemic and are on the other side, and we really need to look at where we're at today. That's just my personal opinion, and I certainly heard it from our community, and I think it's important that we demonstrate that we're listening to them. I also would like to see us on the retreat agenda, and maybe we can follow up with this. I'm not sure how we can do this, city manager, but follow up and have a follow-up debrief on the Plymouth Housing Project, because I think it's incredibly important that we recognize the lessons learned from this experience. This isn't the end of providing any form. I mean, we have opportunity to provide permanent supportive housing. This project wasn't the right fit for multiple reasons. And it's not due to the lack of care and concern for our community. I do, and this council, me personally, and I think I said it last Thursday, I am sorry that I missed some really important things. It was a lot of learning on the dais on my part. And as the project moved further and further along, I hadn't caught my alarm bells until after the fact. I wish I could have caught them sooner. I owe our staff an apology for that, as well as our community. So I own that. I don't want to be in this position ever again on a project of such importance. Approximately $40 million is a lot of money, and we need to do things right in our community. So anyway, I'm just taking my ownership here, making sure it's very clear. Because we have people in need, and it's our responsibility to do everything that we can to support them within our means. And I see our community caring in this way, and I have faith that we can do something, and I think we can do something that is better. And I do think, yes, town halls, we need to actually do it while the iron's hot. But I believe in us. As I said last week, we learned a lot. I am really sorry to people who have, I'm sorry to Plymouth Housing who put so much effort and money into this project that we didn't catch it sooner. They are a valued organization in our region, providing incredibly important services to the most needy who have the most problems. They are an incredibly important organization, and one that I do support, and I'm very sorry that their hearts were broken on this project. But we had to do the right thing right now, and we can learn from that lesson. But community, Nathan and I were at Coffee with Council. On a lighter note, we were at Coffee with Council on Saturday. We had at least 25 people show up, and it was awesome. It was really cool. We might have to bring Robert's rules to Coffee with Council. But keep coming, and we may have to have more coffees with council or alternative ways to gather. But town halls, coffees with council, seeing your faces, hearing your voices. One of the things that may have gotten lost at our Coffee with Council last week for anyone who was there is that's an opportunity for you to share with us your ideas in a less formal environment. And this was more a little bit about report out or, question answer. It was a little different than our typical, but we'll grow. I just was really thrilled to see so many people there. I'm thrilled to see so many people here. You picked the most boring meeting of the year. I promise OPMA, PRA, and anyway, public records. I work in public records, but that's another story. But just saying that those of you that were here for the first 90 minutes, thank you for enduring it and sitting through, because we do care about what you have to say. I'm really thankful to see this engagement. I want to see this city be a model for the region on how we come together and address affordability and homelessness so that other cities can learn with us. And what we're doing here, and you give me hope. It gives me hope to see people show up. And that's really what it's about. When we have hope and when we see each other, we can work together. We give others hope. We recognize our power. And that is really important. So thank you for being here. Thank you to council, because we just went through a really tough process and we're going to have more big, important projects coming up. It's not all easy, but I'm thankful to be here. And I think that's about it. So thank you.
Yeah. Yeah, I appreciate what all my colleagues have said, and I appreciate what I heard from the audience today. And, you know, we still have a lot of work in front of us. In fact, now we have more work, but we have a lot of work in front of us when it comes to kind of meeting some of to meet our housing needs as given to us from the county and the state. I'm just looking here, we have something like 1,600 units of 0 to 30 AMI that we need to figure out as a city, and 559 units of that is permanent supportive housing. We also have almost 500 units of 30 to 50% AMI and almost 400 units of 50 to 80% AMI. Almost all of our housing growth in the next few years, except for about 500 units, is going to have to be under 100% AMI. So we have a lot of work to do, and it will result in change and will result in things that not everybody's totally comfortable with, but we do have to accommodate growth. One of our biggest issues right now as a region is the lack of investment that we have made in housing. We are the least housed state in the country. We have less housing per family unit than any other state in the country. And that directly feeds into things like the housing affordability crisis that we're facing right now, where I wonder, where is my kid going to live in a few years when she's done with college? So we have to do better. We have to do more there. And, you know, I hope that we do continue, you know, town halls. I think the last one that we had with the tables was great. I'm glad that idea worked out. I'm glad that people felt, you know, welcome and had great small conversations. I'm really sorry I wasn't able to make coffee with council, but my HOA had scheduled a chimney inspection, and it's like a cable appointment. They give you a large window and you just have to be home. So I couldn't get out. And I heard it was great. I think we might want to think about reserving the tables outside in the larger space, maybe for a meeting or two, to see if that sort of turnout continues. And if not, we can go back to I can never remember if it's the Beaver or the Otter room, but to the smaller room. We might think about just reserving the tables though, so that we have more space kind of out in the open for folks. So we can have really great conversations with folks, because it is important. And it is much more enjoyable than public comment and comment from the council back to the public. So we do appreciate that. And I hope that we can make that a more regular thing along with the town halls. I'm trying to think. Oh, one thing that did get flagged for me is that we did miss one appointment. I'm not sure if it was in the agenda item or not, but it was to the Regional Crisis Response Agency, RACER. They have a principals assembly, not less than 3 times per year. The first one is Wednesday. Councilmember File, I believe, was on that for us.
I'm on that.
Oh, you're on that?
Yeah.
Oh, okay. Okay. Maybe that is why it wasn't on the list. All right, well, wonderful. With nothing more. Oh, and I understand that somebody here was collecting soup cans or food. Okay, great. I'll bring what I brought back later. With nothing more to come before us, City Council is adjourned.